Sí, sí. Rajiv sir. Rajiv sir. Rajiv sir. Sir, am I audible, sir? Rajiv sir. Rajiv sir, can you hear me? Rajiv Chandok sir, can you hear me, sir? Check. Rajiv Chandok sir, can you hear me? Rajiv Chandok sir. Rajiv Chandok sir.
Yes, sir. I want to mention an unlisted matter, sir.
Fine, sir. When court begins, please raise your hand. I will unmute you. His lordship allows, sir.
Thank you, sir.
Fine. Welcome.
Yes.
Let's
So,
name
may I
it.
please-
Civil Appeal 7463 and 7464.
I'll say my morning mantra. Everything that can be said on an email, please say on the email.
You've said so much.
Said it.
Urgency is this, my lords. It's a waste to energy plant that is stuck up. Your lordships had issued notice in November of last year. It's showing on the 21st. I just requested not to be deleted, my lords. 3 times we've done that because we require some interim orders.
Please, my lords,
Right.
this is a matter wherein we had mailed yesterday also and today also. This is a matter pertaining to the Rajasthan Civil Judges Examination main. The urgency is that today the interviews are to be conducted, my lords. In fact, yesterday,
Was
please, my
my
lords.
courtmaster sometimes have a better memory.
No, there was a connected matter which was listed as item 40.
Called out. Nobody was present yesterday in the court. We didn't dismiss it in default. We've kept it tomorrow.
Please, my lords, may I say one thing, my lords? That matter was not filed by me. In fact, the counsel is
Look,
here. I had filed a similar, which was mailed yesterday also by way of. And today also, the urgency is that the mayor interviews to commence today, my lords.
Both matters are listed together. We'll take it up tomorrow.
My lords, the only grievance is this, my lords. Interviews are to commence today, my lords. At any time at today, even end of the board, we are ready to do that, my lords.
But ma'am, we'll take it up tomorrow. If you find something irregular, we have to just reverse it. It's the easiest thing in the
Then I am with my lords.
Don't worry.
Would you,
Please, my lords.
would your lordship
This is an unlisted.
Let it not be
Because it's
deleted, my lords.
officers, we didn't dismiss it in default or anything. We just kept it for tomorrow. That's
Please,
it.
my lord, let it be at the top of the board tomorrow.
I am in that
Ma'am,
connected.
now this is just stretching a lot too much. So,
Sorry,
Lordship,
sorry.
permit me to mention the BAFTA
Yes.
Motors contempt case. Justice Pardiwala had passed an order directing it be listed on Friday as the first matter of the day. It's a matter in which I've paid 129 crores and they've not handed over the property still. It's not come on the list. If it is item 1 as directed, your lordship, there's a
Friday, I just gave instruction.
May I please,
The
this is the
bench
matter.
of my lord, Justice Pardiwala and Justice MISRA will take it up. We'll carve out a space so that you will get a hearing on that day.
most grateful.
May I please, this is the matter,
It's a very short mining matter. We paid the amount. Only formal orders are required by lordship. It was to be listed yesterday. We sent the
It's
emails.
an after notice.
It's in that common cause matter, my lords. We paid that amount before your lordships, my lords. We've deposited it. It was to be listed yesterday. Very short matter, my lord. 30 seconds it will take, not more than that. I have one.
The call. I'll just send an email.
I'll just point out the difficulty. I bow down, my lords.
Anyway, I'll take a call. Don't worry. You mentioned the matter.
My lease will lapse if your lordships don't.
All right, you will.
May I please, Malas,
May
this is an
I
after
mention the
notice
medical
matter.
college matter, Malad? For medical college matter, PG admissions tomorrow is the last date. I believe yesterday we circulated an email. Today morning also we have circulated an email. The date is showing as 21st. Tomorrow is the last date for admissions. Would you just kindly see it?
May I please, Malas, this is an after notice matter, Malas, in which your lordships had passed an interim order dated 9 January 23 to extend the tenure of one Mr. Narayan Swamy for the post of judicial member in the Karnataka Administrative Tribunal, Malas, and he has completed his service for a period of 5 years, Malas, and has also turned 67 years, despite which he is continuing for the post in the same post for 2 years.
Who are you?
I am for the Registrar Karnataka Administrative Tribunal, Malas. Respond number 3. Malas, the tentative date is
When is the tentative?
the 18th October, but the list is out. My matter has not been listed, Malas.
All right. If this requires early hearing, we'll take it up.
I'm so grateful.
I mentioned matter of Temple of Hearing matter, which was in adoption directions were to be given.
Temple of Healing is an ongoing matter. It can wait, ma'am.
Lord,
We have passed various directions on adoption.
it's almost complete. The final directions have to be given by the lordship.
Yeah,
It's listed on 21, it's not to be deleted.
Okay.
Anyways.
Malat, previous matter will hold this today, Malat. So
what, sorry?
previous matter, Malat. I'm only requesting you to keep it tomorrow, Malat.
We'll see. Let the matter be called out. Yes.
Oblige, Malat.
Yes.
My lord, I am a petitioner in person. I'm mentioning a matter, enlisted matter. My lord, I'll file a petition. My lord, what has happened is vacancy for the member to the NCDRC has.
Mr. Chandra, you have to still file a petition, right?
I will send an email first because my lord, today is the last day and I'm not able to.
But file it first. Then we will look at it. We can't.
I don't have an advocate and record.
You file a petition. Yes. What?
My lords, item number 1, I have instructions to withdraw the
All right.
petition.
Withdraw.
My lords, in item number 2, I appear for the petitioner.
Yes, yes, yes.
My lords, I have not been able to get in touch with my client. He stays in US, but my learned friend, counsel for the respondent, has filed an affidavit on record, which shows that the matter has been settled between the parties.
All right, then we will close it. We will say that we had recorded that statement on the last day, that you have no further instructions, but we'll therefore, on the basis of the respondent's statement, we'll close the proceedings.
I'm grateful, my lords. I'm grateful.
On 27 September 2024, this court recorded the statement of the respondent that there was a settlement between the parties and the petitioner had agreed to withdraw the present proceedings for the appointment of an arbitrator under Section 11 of the Arbitration and Conciliation Act 1996. We'll stop next. Ms. Mayuri Raghuvanshi, learned counsel appearing on behalf of the petitioner, states that at this stage, that her client, the petitioner, resides in the US and she has no instruction and no instructions are forthcoming. There is no basis at the present stage, therefore, to dispute the statement which has been made. He has filed an affidavit, right?
Yes, my lords. He's filed an affidavit.
By the respondent on affidavit. Full stop. Consequently, the petition is disposed of at this stage. To apply for restoration. Yes.
Grateful, my lords.
May please, Lordship. Lordship, I beg to appear for the petitioner. This comes up after notice, Lordship. This is a Section 11 petition. As per the office report, the respondent stands served, Lordship. Nobody has entered appearance.
Where is the seat of the arbitrator?
Lordship, New Delhi.
It's in New Delhi.
Lordship, please.
Okay. It's in New Delhi, is it? And how much is the claim is about 2 crores?
Lordship, as on date with interest, it's around 3 crores odd, Lordship.
Ms. Mayuri Raghuvanshi was appearing just in the previous matter as the sole arbitrator.
Lordship, please.
All right. And arbitration to be under the DISC, auspices of DISC.
Lordship, please. Deeply obliged.
Ms. Raghuvanshi, we have just appointed you as an arbitrator in this matter.
Grateful, my lords. Grateful, my lords.
Lordship.
4.
My lords, we are just nearing settlement. My lords, may kindly indulge us for this last opportunity. Maybe by a couple of months, my lords, we should be able to finalize.
When the matter is
because I know it's been quite a while, but my lords, unfortunately, the other side, my lords, is based in the US, so very seldom that they are able to make it.
On the request of the learned counsel for the petitioner, who states that parties are on the anvil for a negotiated settlement, which is at an advanced stage of discussion. List on, keep it sometime in January.
I'm obliged. Because I think my learned friend who's also appearing on VC has the same instruction.
All
Obliged, ma'am.
Make both, take the appearances of both parties.
Yes, I'm obliged.
This is actually an application under 29A of the Arbitration Act for extension of time. This is not for appointment. Just 2 facts can I indicate what happened, Mills. The Bombay High Court by consent appointed an arbitrator on 28th March 2018, Mills. Though it was an international commercial arbitration, by consent an arbitrator was appointed. Pleadings were complete, Mills, in 2018 itself. But what happened, my main document on which I am relying upon was said to be unstamped. That is, the Internet License Agreement was stated to be deficiently stamped. So that got impounded and was sent to the Superintendent of Stamps for adjudication on 18/7/2019.
Who sent that?
The arbitrator himself. Lordships will have page 33.
Which is consistent now with our judgment.
Yes, Mills. Page 33, 36, your Lordships will have, Mills.
All right, we'll take your word for it.
Yes, Mills. So then that adjudication has not taken place. Without that adjudication, the arbitration has stuck. And therefore, Mills, the time period of 1.5 years, 1 year plus 6 months has got over. So we went to the High Court for extension. High Court said since it's international commercial arbitration, your Lordships have to be approached for extension of time.
But if it's an international commercial arbitration, there's no time limit as such.
Yes, in view of my Lord's Tata Sons decision, as well as amendment to section 29A, this petition is misconceived. There's no time limit. In fact, arbitrator is more than willing to continue with the arbitration.
But he never
because of the...
There is no time limit for an international commercial arbitration.
the arbitrator indicated that he can't until.
Who's the arbitrator?
Mr. Mikhail Bhel, my lord, advocate, my lords.
No, my lords, even after the 1 year was completed, arbitrator has addressed 2 emails to the claimants asking them to take steps for adjudication, and those steps have not been.
Right. Lordship may do that. Lordship may say that, my lords.
And this is only an application for extension.
Yes, yes, my lord. Lordship may say that, my lord.
The application is for the extension of time for the completion of arbitral proceedings. Next. On 28 March 2018, we have heard Mr. Gaurav Agarwal, Learned Senior Counsel, and for the petitioner, and Mr. Akshay Patil for the respondent who appears online. On 28 March 2018, the High Court of Judicature at Bombay appointed a sole arbitrator by consent, though, it is common ground that the arbitration is an international commercial arbitration. Full stop. It transpires that the Internet license agreement was unstamped and was hence impounded by the arbitrator on 18 July 2019 and was sent to the full stop. The arbitration agreement was sent to the Superintendent of Stamps for adjudication of stamp duty, and the matter rests there. On this ground, an extension of time for completion of the arbitral proceedings has been sought. Full stop. Next. The Arbitration and Conciliation Act 1996, it is common ground, does not impose any time limit for the completion of an international commercial arbitration, as in the case of a domestic arbitration. Full stop. Hence, no formal extension of time is required to be granted by this court. Full stop. As a matter of fact, Mr. Akshay Patil, Learned Counsel for the respondent, has also submitted that the arbitrator has continued to act beyond the period of 1 year by addressing emails to the parties. Full stop. In view of the above clarification, no further directions are necessary on the application, which is accordingly disposed of.
Obliged.
Grateful, Minister.
Item 6.
Item 6, Your Lordships, is an application under Section 11 for appointment of an arbitrator, Your Lordships. Respondent number 2 is based out of Dubai, so that is why the application lies before this court.
Yes, my lords, I am appearing in this matter on behalf of all the respondents.
So we'll appoint an arbitrator?
Yes, my lords, we do not have any objection regarding that.
Usual order. And we'll appoint Mr. Kanu Agarwal, who appears all the time in here with the solicitor as a sole arbitrator. It's 3 crores, no point in appointing a retired judge. Mr. Kanu Agarwal.
Please, Your Lordship.
Very pleased. I'll just briefly supplement the points that were made by Mr. Rothke and a few other points which have not been addressed. Just if I can just first confirm, my lords, there's a binder that I had uploaded yesterday. Just want to confirm that your lordships have that. It's brief compilation of points.
Yes, sir. On
Yes.
There's a note to binder, right, on behalf of Mr. Gopal Shankar Naik?
Yes, yes. It should have, in its index, it should have 10 serial numbers.
Yes, yes.
Is that right?
Yes.
Now, if your lordship can just keep that aside for a moment, I just wanted to ensure that it's there. Well, this case falls actually in a much narrower compass than the magnificent canvas that has been painted upon by my friend.
Including by your learned senior on your side as well.
Because of the magnificent canvas he had to respond to. So if I can just briefly put it.
Yes.
When we respond to the invitation to come in with a resolution plan, what we say is this. We have certain conditions precedent we impose on ourselves. We give an implementation schedule. Your lordships have seen that implementation schedule, which has 3 letters, X, Y, and Z.
Yeah.
X is the date on which they accept and we get the LOI. That's in the implementation schedule. If your lordships want to just look at that.
No, that's okay. We remember that so well now.
You've seen that. So, Y is the date of the approval, which the NCLT gives to the plan.
Yes.
And Z is the effective date. The effective date from which the plan starts getting implemented.
Yes.
I just want to spend like a minute on this because this is critical. From Y, which is when the NCLT gives its approval, there's no objections, etc., to Z is the period during which we have to satisfy conditions precedent and nothing else, only conditions precedent from Y to Z. In that period of Y to Z, those conditions precedent, your lordship saw 5 of them. In those 5, they took objection really only to 3 of them before your lordships here. 2 of them are admitted, and that's what even NCLT and CLAT say, those are admitted. If I satisfy those conditions precedent, I get the keys to the company. I have hit effective date. From that,
Take your seat.
Yeah.
From that effective date onwards, I start implementing the plan. That is Z plus 180. I hope I'm making myself.
Yes, yes.
Now, in this period from Y to Z, they say you have not satisfied conditions precedent. And this they don't say now. They've been saying it from 2022. While I say that I hit Z on 20th May 2022, they say today, standing in the Supreme Court, they say I haven't hit Z. I hope I'm making myself clear.
Yes, yes.
So it's only once I hit effective date that I get the shares to the company. At the very least, commensurate to the 200 crores that I've put in, I will get those shares. I activate the company. Applications go on the letterhead of Jet Airways to the various authorities.
So according to you, nothing really is kicked off until Z is, as a matter of common understanding, achieved on 20.
Common understanding. Those are the exact words.
We'll hear Mr. Rodhi also touched on that. We have to ask Mr.
So now, one of the charts here shows you extracting from each of their previous pleadings in their previous appeals, which came all the way up to the Supreme Court, including this particular appeal, what their stand has been on this. Note 5.
Mr. Shankar, as usual, you are very meticulous with coming in as the last counsel, but you give it very precisely. Which is that chart?
The note 5. Note 5 at pages 7 and 8. Lordship can see the stance.
A note on the appellant stance.
Yes, a note on the appellant stance.
We got the point. We'll look at it later. But
just see that note. So I'm not going to read those notes.
So your claim, in other words, is that look, irrespective of what I was doing, the fact remains that they never accepted that the conditions precedent were fulfilled.
Correct.
And unless there is a commonality of intent between parties that conditions precedent or the CPs have been fulfilled, how can anybody find you in default unless the other side has accepted that 22nd May 22 was the condition precedent?
Absolutely.
That's the point.
So that's point number 1. So note 5 will deal with that. I have actually quoted and extracted with the page numbers of each of their documents. Just see those 2 pages, that's all.
That's okay, Mr.
Which will end with their appeal.
No, that's okay. You made the point.
That's point 1. Point 2, on the back of that, is that if, and this is their stand, not mine, their stand, if I haven't reached effective date, then you can't say that there are the aspects of implementation of the resolution plan where I have defaulted. Because it is your case that I haven't reached effective date. If I haven't reached Z, you can't hold me to account on days after Z. So everything,
then
yes.
This logic actually, it's very attractive, but it will create one problem.
Yes,
which would mean that, the achievement of the effective date is in your hands.
That's completely
now.
Yes.
Going by their contention,
yes,
you have not achieved effective date.
Yes.
Now, if you say that, look, there is no commonality on effective date,
yes,
therefore the rest of the obligations don't kick in, that means this will be left now in the indefinite future.
Which is why I have
10 years.
Which is why I have not.
That would be a very impractical assessment.
Which is why I have note 6.
And second, the fact that you pumped in 200 crores,
yes,
is itself an indication to us that you at least were, and they accepted it.
Yes. So
therefore, the effective date had kicked in. Otherwise, why would you pay the 100 and 100 crores?
Respond on both.
Manoj Mishra says that, once you take the point that effective date has been achieved,
yes,
and you have, that's your stated position, yes, you can't go back on that.
No. So I'm not. I'm grateful for that. That is correct. I'm not, which is why I have note 6. Note 6 deals with, and this is what the NCLAT dealt with at length. What was the role of the lenders once I have achieved effective date? There are several steps that they have to take. We keep sending them letters, emails saying, look, we have coughed up the entire PBG. We have paid 200 crores in addition. Please ensure that the security creation is created on the Dubai assets. RBI has written to them. RBI has said, look, I'm not going to act. You can't throw that.
Note, because Mr. Rothgi touched on this yesterday, but now you have formulated
it. I have formulated that note 6, please note.
Give us those 2 emails, they said they responded only 24.
It's not 2, it's about 40. Now, we can't trouble you with that, which is why I've put it all in that note, which tells you that on each of these parameters, this is what they had to do, which they did not do.
What is the next point?
Third point. I'm afraid that we have not, neither of us have taken your lordships through the entirety of your judgment of January. Now, if your lordships were to go through the entire judgment, and I'll give you a reason why, you will see what the contentions are that were taken by them, which included not only this issue of this affidavit, this interim arrangement, but also conditions precedent are violated. His argument, its 4th argument, which your lordship have listed out in para 4. Separately, your lordships have extracted the implementation schedule, the timelines, the conditions precedent. You have extracted all of that. After which, and I'm now leaping to the end because there are several observations in the middle which make it clear that your lordships were only within the remit of that affidavit and the interpretation of the word infusion. That's all. Now, as per my XYZ schedule, I had to bring in 350, your lordships have seen, as per the resolution plan. Now, as per the resolution plan, I bring in a 150 PBG. It says 42.5, but there's an addendum which we have put in our convenience compilation, accepted by them, which made from 42.5 became 150. I had to bring in 42.5 between Y and Z. I had to bring in the balance by Z, which is 20th May. On 27th May, I sent them the email. Your lordships have seen that. I've annexed it here as well, which shows that the remaining balance amount, which was 102.5, we have, it's 87.5 at that point because we have already paid 15 earlier. 87.5 we have brought in on 27th May 22. So as far as PBG is concerned, 150 is there. We were supposed to bring in 200 crores only after Z. I hope I'm making myself clear. Yes. Only after Z. The reason we brought 200 crores before Z is because they in their affidavit said, look, we will not press our appeals, we'll withdraw it. You bring in 350 now. And they gave us a timeline saying now. The now we believed would allow us to bring in 200 in cash and 150 in a PBG. NCLT agreed, your lordships took a different view. Your lordship said, no, make 150 also cash, which I think is a reasonable interpretation because if they're anyway going to get 350 at a later stage, why get 350 at for earlier stage in the same form?
Right.
They obviously wanted it in cash. So your lordship said, if you're going to accept that affidavit, it's 150 which is going to be in cash that you have to give in 10 days. We sought an extension. Your lordships didn't accept that. Just see your directions. Just the directions.
Tell us, we've seen it so many times now yesterday.
No, I know.
Just
the reason.
Tell us what that direction which you are relying upon.
The reason why I wanted, I'll just read those.
Read it.
It's three directions. It's at para 25.
No problem. Just read it.
The directions are as follows. 1. The SRA shall peremptorily on or before 31st January deposit an amount of 150 crores into the designated account of SBI, failing which the consequences under the resolution plan shall follow. It should have ended here. There was no reason for two other directions. Because...
What are the other two directions?
The second direction is the PBG of 150 crores shall continue to remain in operation and effect pending the final disposal of the appeal before NCLAT and shall abide by the final outcome of the appeal and the directions that may be issued by NCLAT. That would become moot if I had coughed up the 100 crores within by the end of January. It can't be both ways, my lords. I hope I'm making myself clear. Either I cough up the 100 crores, all appeals come to an end. Or I'm not able to give the 100 crores in cash, which is something which was within the contemplation of this court because your lordships had put out the resolution plan conditions in your order.
By then, how much had you deposited?
200 in cash at all.
We asked you to deposit another
150 which had to come in. Your lordship said it can't be a PBG, which is what I'm permitted under my resolution plan.
So we said that, look, you deposit the 150 crores.
If you want to avail
plus,
of
and plus PBG.
Correct. If you want to avail of this, make this 150 a cash 150. So rather than a 350 later, which is 100 plus 150 PBG, today it's already 100 has come in. The remaining 150 can't be a PBG. It has to be cash. That's what your lordship said. And your lordship said in that first direction, it has to be by 31st January 2024. Because we couldn't cough it up in cash. What is the consequence? Directions 2 and 3 kick in. Otherwise, directions 2 and 3.
Sure.
So direction 3 after that says, whether or not the SRA has been compliant with all of the conditions of the resolution plan, which is post conditions precedent, that as well as the conditions set out in para 8 of the affidavit dated 16th August shall be decided by the NCLAT in the pending appeal. Now these two directions weren't required if I brought in 100 crores. If I brought in 100 crores, matters over. So the remaining two directions, and there are several paragraphs, so para 19 was read to your lordships, etc. Several paragraphs throughout, just if your lordship, I'm not going to read it, but the entirety of the judgment. And the reason why I'm saying this is this, Manoj. I think there's some responsibility with reference to a former judge of this court who was sitting in the NCLAT with a group of members who have spent 108 pages on the impugned judgment. Now, I'm not going to read that impugned judgment, but I'll tell you what it deals with. The impugned judgment splits itself up into issues. If for a minute I can show you just the issues, not the 108 pages. They spent 35 pages on interpreting your lordship's judgment. They go in granular detail into every paragraph and say at the end of it that clearly the court's understanding and interpretation was with reference to your affidavit, not with reference to the resolution plan. It couldn't be with reference to the resolution plan. Why? Because the resolution plan implementation stage hadn't come yet. Z plus had not come yet. The only issue before NCLAT was the question of whether conditions precedent had been met and whether the 13th January NCLT order was correct. My Lord Justice Pardiwala, I understand yesterday, put that question regarding para 120 of the NCLT judgment, of the 13th January judgment, whether it was, they may have some inconsistency in their finding, the NCLT's finding. NCLT looks, if you go about 3 paragraphs prior to that, NCLT goes into the various aspects of extension and says that, look, because of the conduct, which is something even NCLAT comments upon, the extension is reasonable to be granted in the stage between Y and Z. So when NCLAT goes into it, if just for a minute, just one page.
With the resolution plan, how much did you have to bring in?
350 cash.
350 cash.
No, not cash. Cash is his word.
Infusion.
Yes. 350 had to be brought in.
Plus 150.
Yes. It's shown in 3 stages. Your lordships can see it. You have extracted it in the judgment. You have extracted in the judgment. and security creation was to be done. Just see page 26.
So Shankar, I've got your point that
No,
ultimately this is the 150 had to be brought in after the effective date.
Yes, so I'm just telling your lordships that there are
I think
8
this has
points.
been all argued yesterday now, but thank you for these notes.
I'm not on anything new. Everything that I'm telling you is not said before. 8 issues are framed by the NCLAT. 8 issues. Your lordships will find this at page 26. It's para 26. I just want to tell your lordships what. The first 4 issues are dealing with conditions precedent. Issues number 5, 6, and 7 are all issues attending the interpretation of your lordship's order. Issue 8, which is the last one, is dealing with what the way forward is, which I believe still exists today. They granted us extension up till that date. Your lordship may kindly grant us extension up till this date. We are in the process of implementation. We just need cooperation, and that cooperation has not come in 2.5 years. Now, if your lordship will now come, I'm just telling your lordship the 100 pages have been devoted to going through each of those conditions precedent separately.
We'll have to look at them.
And for the satisfaction of conditions precedent, there are several. We don't want to burden you because this is effectively a second appeal by them. Hundreds of emails, correspondence, notifications, exchanges with regulatory authorities, etc., which NCLT perhaps doesn't go in that detail, but NCLAT does. And NCLT and NCLAT are concurrent in our favor. There's no substantial question of law that has been shown to you except a lot of prejudice. No substantial question of law yet framed. Even now, my friend has not framed the question of law which is required under the law. Now, just for a minute, that binder, I'll just touch upon what it deals with and then I'll conclude, Manoj. Just before that, I just wanted to hand this up, Manoj. It may just make it easier. The 3 copies. It's the first page of that binder, second page of the binder. It's the first note. It may be too tiny for your lordships to see. It's to show how
It's
these.
actually quite clear. You can look at the note only.
Very well. I've just handed physical copies if that will be easier.
It's very nicely.
So you can.
Page.
So the yellows are to signify what. Just give the other side. Yellows are to signify what was under challenge and what I'm not going to go into that. Just please note these were the 3 appeals that eventually came to your lordships. Your lordships heard all of them, finally gave a decision only with reference to the infusion issue. And the rest of it, after which we mentioned, the second note deals with the 5, that's page 3, Manoj. I hope all your lordships have it. The second note deals with conditions precedent. I've mentioned the page number. CC refers to convenience compilation because the resolution plan is there in the main appeal, but the addendum as well as annexures are not in the. That's why I put this.
To be fulfilled as per SBI affidavit and subsequent.
Correct. The third is what is as per the SBI affidavit. So it's not as per the plan. So the cash that my friend keeps mentioning raised its ugly head only here at a stage between Y and Z, not thereafter.
4 is extension of time for
implementation. This is extension of time for implementation. So first 4 extensions they had no objection to. They were completely on board with the extensions. So much was made of the fact that there were many delays by us. We have explained it fully here. Note 5 is the stance, the inconsistent stance we believe. Even in the present civil appeal, which is the very last point, you will find that they say second bullet point, the SRA failed to fulfill the above CPs and erroneous. If you have failed to fulfill the above CPs, then according to you, we haven't reached effective date. Yes. But note 6, which is the conditions in the resolution plan and their status. Without prejudice to my argument that you really can't hold me responsible to this because we haven't reached this account to you, we are still showing you that to whatever extent we can be compliant, we have tried to be. But this is the last column is critical in this note. This is what they have to do, which they haven't done. And we have shown each of the emails, the communications, etc. on each of these points. PBG has been done, so PBG is not a problem. Everything else. Now, page 14 onwards, my lords.
Other communications which you said, there were 40 communications.
No, this is slightly different. Your Lordship will remember that a affidavit was handed over here saying that I don't have security clearance. I don't know why SBI should bother getting into anything after the date Z, because it doesn't concern them. But because prejudice has been created, we have put the documents to show this is our exchanges with Ministry of Civil Aviation. They ask for passport details. We have put all of this. This goes on all the way up to, I think, page 44 to show
what obtained it, Mono. That's our point.
We'll hear you in the joint.
Very good. I mean, what I find at page 31 is dated 16th August 2024, and it says this para 2 at page 31. This security clearance is, however, subject to the following condition. Now, anyway, this is not relevant to them. I have got this. It's not like I've been sleeping and sitting back. I've been taking all these steps, hundreds of steps. The SBI forgets it's the SBI. They are the ones who gave all these loans to a previous company without enough security, and that's why we're floundering now. Let's not act holier than thou about this. I'm not the bad guy. I'm the one who's trying to get this company back in the air. The reason for this prejudice, I just cannot understand. Somebody's trying to get a third airline up in the air, and you, for reasons best known to you, SBI, who has been left, right, and center allowing companies to flounder. If I wanted a home loan for 50 lakhs, they won't give it. But for everything else, for thousands of crores to previous administrators, they're more than happy to give it. Just see page 33 for a minute, Manoj. Now, these are three specific charts. 33, we have just extracted again regarding the PBGs. What was the stated in the affidavit, what was stated in the resolution plan, and how those two are very different from each other, and how we have complied with it at 36, which is that the earnest money of 15 crores, the first tranche of 47.5, we have taken screenshots from the pleadings itself with the page numbers, so your Lordship can see. Those are all printed page numbers, not the PDF. And finally, at page 37 is our email of 27th of May showing that the last 87.5 came in. So they're fully secured. This is apart from the BKC property, which they could have put in the common pool to take care of workmen and everybody else, which they chose not to and they're clinging on to. So they've got BKC property. They've got 350 crores, 200 of which is in cash. They should have given me shares against the 200. I still haven't got one. They have also got the Dubai properties on which security has to be created. The NCLAT in the impugned judgment says the way forward, first thing is create the security on the Dubai properties. You have that also. Page 38, airport dues. We have shown how the airport dues has to be treated. So on this and the next last point, just one common fact. Both airport dues and workmen's dues, these submissions repeatedly have been, it has to be upfront. The word is upfront. Now, I don't know where my friend gets upfront from. As per our resolution plan, airport dues falls into two groups. One, which are part of the CIRP, so part of the resolution plan, and I have to pay that. Thereafter, I have to pay it. It's my burden. It doesn't trouble him in the least. Why is it troubling him? Because he dragged this issue through the courts for 2 years. The airport dues kept going up and up and up. Now he feels that it will reduce his share if I have to clear the airport dues from the kitty of the company, because there was a positive cash flow in that company. So from that, he feels threatened by it. As far as workers' dues are concerned, there is a separate appeal, your Lordships know. When we first envisaged our dues as far as workmen's dues were concerned, we specifically said in our resolution plan, we've extracted it, that if there are any gratuity or PF dues, because we were not told about it, not in due diligence, it was not in the RFRP, nothing was told to us, we said that will be treated as nil. Subsequently, we're told about PF and gratuity dues. The PF dues are statutory in nature under Section 11 of the PF Act. So that I have to do upfront, which is that amount of 14 crores. Gratuity is doesn't have a statutory provision like that under Payment of Gratuity Act. However, when we challenged that and we came up to this court, we were told clearly, no, you have to cough up that entire amount of 200 odd crores, all told. So we have now made accommodation for that in the plan. Our plan is a 5-year plan. In that plan, the lenders get paid over the 5 years. The workers and employees who otherwise will not get the money anywhere else are getting paid over the 5 years. But to ask for it upfront, the 14 crores is upfront. Liquidation value 113 crores is also being given upfront. 113 plus 15 is upfront. I hope I'm making myself clear. So it's not like they're going away penniless. They are getting also their additional 180 crores odd. How much is it? 188 crores odd of gratuity over the staggered period like everybody else, because the law allows me to do that. If the law told me, no, you have to give that in priority at the outset, my plan may have been different if I had projected a plan at that stage. So this is explained in both this and the next. Really, as far as the lenders are concerned, they have no call to have an issue once effective date has kicked in, because that is up to my implementation. You haven't allowed me to implement. Today, when he keeps saying it should go into liquidation, who is going to give me my 200 crores back? I ask myself. You got that 200 crores by virtue of an affidavit at an interim stage in the NCLT saying, I'm going to withdraw my appeals. I have no obligation to give that 200 crores. I pumped that in. That 200 crores is sitting with you. He's not going to give me the 200 crores. It's all very well for him to keep saying, you have taken money. I haven't taken a single penny. I haven't got a single penny from anywhere on this. I have lost 200 crores. So my suggestion, my lords, eventually is this. The way forward, which is spelled out at the end of the NCLAT order, that way forward should be implemented. The timeline extension we still need, because the 180 days which we are guaranteed will happen only once we have final verdict on effective date being hit.
Right, thank you.
I'm grateful.
Thank you. Yes, Mr. Venkatraman, what do you have to argue?
Good. Before your lordships conclude, I have placed my 2-page note
All
and
right,
the
we'll-
application number. Peace protection relief that is.
All right, we'll look at it. Yes.
Great.
Lord, we have given we have placed on record a note, my lord, our submission, rejoinder. We'll give a copy to you. Exactly 15 minutes, not more than that. 6 points, 14 pages. That's it. May I read more?
Yes.
Court has it? Yes. But first issue is on the first tranche payment of 350 crores. Mary. The respondents have not adverted even remotely to the following. Clause 3.13.1 of the RFP obligating execution of rupees 150 crores of PBG. Clause 3.13.9 of the RFRP makes it clear PBG shall not be set off against or used as part of consideration even if expressly indicated in the resolution plan. C. Clause 9.4 of the resolution plan permits invocation of PBG in terms of RFRP. D. Clause 3.13.7 subclause 3 of the RFRP entitles invocation of PBG without any reference to the resolution applicant for failure to implement the approved resolution plan to the satisfaction of the COC and in accordance with the terms of the resolution plan. Clause 7.7 of the resolution plan obligates infusion of rupees 350 crores in the corporate debtor within 180 days from the effective date. The effective date as per the SRA is 25/2022. 180 days expired on 16/11/2022. SRA is what? 180 days expired on 16/11/2022. NCLAT extended 180 days till 31/8/2023. Infusion has been interpreted by this court as only by means of a cash payment. Therefore, the assumption by the respondent that infusion of 350 crores emanates only out of the affidavit filed on 16/8/2023 is totally incorrect. Affidavit dated 16/8/2023 has not and cannot impose any condition over and above the resolution plan since the respondents had not remitted even a single rupee. Affidavit dated 16/8/2023 was filed, setting out a deadline for infusing 350 crores by 31/8/2023, which was extended by the NCLAT to 30/9/2023. The affidavit was only insisting on compliance within specified timelines, and neither did it alter the resolution plan nor put new conditions. This is our case. That is why this Honorable Court, while rendering its judgment on 18/1/2024, made it clear non-infusion of 150 crores of cash would lead to consequences both in terms of the affidavit and also the resolution plan, since the condition as far as infusion remains the same both in the affidavit and in the resolution plan. The Honorable Court held at para 22, having by its conduct accepted the terms set up by SBI, it must be obligated to comply with the entirety of its obligation. It must do so in strict compliance with the time schedule set out hereafter. Para 24. Such a state of affairs cannot be permitted to continue interminably, as it defeats the very object and purpose of the provisions of timelines under the IBC. Para 25. In order to furnish this SRA the final opportunity to comply and consistent with the above position, we issue the following directions: deposit amount 150 crores, failing which the consequences under the resolution plan shall follow. Alternative submission by the respondent. Respondent counsels conceded before the court that in terms of the tabular statement, respondents can adjust the PBG upon execution of the mortgage of all the 3 Dubai properties, which the respondents have failed to do even today, even in terms of the extended timeline granted by NCLAT by the impugned order dated 12/3/2024, granting 30 days time, which expired on 11/4/2024. The respondent's reply was that RBI permission was granted in July 2022 only, and they were always eager to execute the mortgage and are ready to do the same even now. This submission is factually incorrect and totally misleading. The exchange of communications as found between pages in the book and again the additional document so and so throw light into the following. A. Total non-cooperation and utter delaying tactics by the respondent. B. When the appellant had conveyed that the cost for creation of charges is 2.36 crores needs to be paid, the respondent replied that 76 lakhs available in the bank account can be adjusted without paying the balance deficit. C. When the extended time limit for creation of security in terms of the impugned order expired on 11/4/2024, the respondents, after sleeping over for 30 days, starts to engage in a correspondence informing that the value of the Dubai property had come down and would pay the deficit of 14 crores in cash, and did nothing, neither executing the mortgage nor paying 14 crores. It suddenly sprang up with a new idea and wrote to the appellants that there is some property in Aligarh, that too not belonging to the respondents, but some unknown third party, which the respondents are willing to execute a mortgage. This offer of a stranger's property in violation of the direction of NCLAT comes after the expiry period of 30 days, exposing clearly the unwillingness of the respondents to execute any mortgage. This court directed that a non-deposit of 150 crores, consequences under the resolution plan shall follow. However, NCLAT, contrary thereto, held that consequences of non-deposit was that the SRA was not entitled to take any benefit of the offer. Despite order of this court, the SRA could not even deposit 150 crores when ultimately he has to pay 4,783 crores in 5 years. In view of the non-deposit of 150 crores, coupled with non-compliance of this order of the order of this court, the NCLAT ought not to have gone into the merits of the matter. In a nutshell, as far as the first tranche payment of 350 crores is concerned, only 200 crores cash payment has been made. The court's direction of infusing 150 crores cash before 31/1/2024 and seeking a further extension beyond that which got dismissed on 2/2/24 evidences the fact that the respondents are in clear breach of this Honorable Court's order. C. Having conceded the fact through their counsel yesterday that PBG can be released only on execution of the mortgage, how could the NCLAT pass an order allowing adjustment of PBG first and execution of mortgage later? D. The required mortgage has not been executed even as per the extended time limit granted by NCLAT order dated 12/3/2024, which had expired on 11/4/2024. Consequently, in terms of clause 9.4 of the resolution plan and clause 3.13.73 of the RFRP, the appellants are entitled to invoke the PBG automatically without any reference to the resolution applicant. As a result of the above, the respondent had failed to comply with the first important condition of the resolution plan. 2. Airport dues. Clause 6.3d in unequivocal terms mandate the respondent to pay the airport dues, which was estimated approximately at 240 crores as on 31st August 2020, subject to a maximum of 475 crores. The plan mandated this payment to be upfront in priority over any other payment to the creditors of the corporate debtor. That's the language used in the plan. It reiterated in the same clause, such payments will be settled upfront. My friend wanted to know where do you get it from? We get it from the resolution plan. Such payments will be settled upfront in full in the first 180 days from the effective date and without any conditions, including not being staggered payments spread across a period of time, so that flying can start immediately without any further disputes and concerns with such claims for the past dues. Till date, the appellants had not paid a single rupee towards airport dues, and their counsel conceded during the hearing yesterday that the entire responsibility of airport dues will be that of the respondent. The airport dues as on date is a staggering 1,100 crores approximately, out of which respondents have not paid anything. No arguments with reference to this clause was made by the respondents. When this is the plain condition for compliance, the NCLAT by paragraph 53 had pegged it down to 25 crores by referring to clause 6.4.1h. A plain reading of this clause makes it clear CIRP cost of the corporate debtor, which is 25 crores, is excluding parking charges, rental charges, employees' dues, taxes, etc., whereas NCLAT had interpreted it as inclusive. The plan was approved by the COC on 26/2019, which was based on the estimate given by the RP that 240 crores as on 31/8/2020 would be payable towards airport dues, which SRA will endeavor to get the dues reduced. At present, due to several extensions granted by NCLT and NCLAT, the estimation given in 2020 will have no relevance, keeping in view that the airport dues in the year 2024 are now 1,100 crores. In case the argument is accepted that only 475 maximum is to be paid by the SRA, then this entire amount of 475 shall go only towards airport dues and nothing becomes payable to the financial creditors, operational creditors, workmen, etc. These were mere estimate of dues payable in 2020, and due to non-payment and non-commencement of flying, the amount today is around 1,100 crores. And to contend that this does not fall under the resolution plan and is not payable will cast further burden on the COC. It is unimaginable and impossible to visualize and accept, for the respondent's default of non-payment would lead to two drastic consequences, namely COC, which has 39 banks, would have to bear the airport dues of 1,100 crores, and neither COC nor OC or workman would get anything out of this plan. This misconceived contention making the plan unworkable needs to be outrightly rejected. 3. Workman's compensation. Page so-and-so refers to the workman's compensation in the resolution plan, which was originally fixed at 52 crores. However, NCLAT by its order dated 21/10/2022 directed payment of 16.5 crores towards PPF and 204 crores towards gratuity. This view of NCLAT has been upheld by this Honorable Court by its order dated 30/1/2023. However, the impugned order of NCLAT by para 111 to 113 had directed the respondents to pay only gratuity of 12 crores, which according to the workman is 16.5 crores, without factoring the balance amounts towards Provident Fund, which it had been directed by its own order dated 21/10/2022, upheld by this court on 30/1/2023. What is important to highlight is para 80 of the order dated 21/10/2022. Because my friend said, where on earth we have to pay workman's compensation? This is the direction we enclad. The workmen are entitled to full payment of Provident Fund and gratuity. Hence, the balance of the above dues ought to be paid by the SRA to satisfy statutory obligations. Non-payment of full provident violation of section 32E of the IBC. Hence, to save the plan, the above payments have to be made. Respondents have not addressed any arguments on this non-compliance, and therefore yet another condition of the resolution plan also stands breached. 4. Effective date. Clause 7.6.2 originally read that the date of fulfillment of all condition precedents, as stated in clause 7.6.1, shall be the effective date for the purpose of this resolution plan, and failure to comply with the same 270 days within 270 days would lead to automatic withdrawal as per clause 7.6.4. However, the NCLT by order dated 22/6/2021 modified clause 7.6.4 automatic withdrawal and granted a period of 90 days and a maximum period of another 180 days more to comply with the resolution plan. The effective date therefore became 22/9/2021, 90 days. But order dated 29/9/2021, NCLT extended it to 22/12/2021. But order dated 21/2022, it further extended it to 22/3/2022. 270 days got over. Still, NCLT by order dated 11/4/2022, by para 20, extended the effective date to 25/5/2022, excluding a period of 65 days for the time spent in moving the applications for grant of time. Therefore, the effective date finally got frozen to 25/5/2022. The question of compliance of a condition precedent and automatic withdrawal got modified once and for all. Effective date as per the SRA and the NCLT is 25/2022. Calculation of 180 days for infusion of the first tranche payment begins on 25/2022. Initial 180 days expired on 16/11/2022. However, by order dated 31/1/2023, NCLT extended the time limit for infusion of first tranche payment till 15/5/2023. NCLAT by order dated 25/5/2023 further extended the time limit of 180 days till 31/8/2023. Again, by order dated 28/8/2023, NCLAT extended it 180 days till 30/9/2023. This Honorable Court, by its order dated 18/1/2024, lastly extended the time limit of 180 days for infusion till 31/1/2024. It is extremely important to highlight: A. The respondents have failed to pay the first tranche of 350 crores within 180 days from this effective date. B. Failed to pay 475 crores of airport dues within 180 days from the effective date. C. Failed to pay 226 crores of workman's compensation to save the plan in terms of section 32E of the IBC. Finally, this court by order dated 18/1/2024 extended it to 31/1/2024, where again the respondents had failed to pay the first tranche payment. It is too late in the day to claim that non-infusion of 150 crores to complete the first tranche payment of 350 crores is only a breach of the affidavit dated 16/8/2023 and not the resolution plan, and the same needs to be rejected outright. Condition precedents. The respondents have failed to comply with clauses 7.6.1a, c, and d of the condition precedents even today. Clause A. Air Operation Certificate. The respondent had an air operation certificate till 25/2023, which got extended on 27/7/2023 up to 30/9/2023 with a clear conditions attached that the extension is only for the limited purpose of completing the ongoing CARP process, and Jet Airways had to undergo fresh recertification and submit a firm action plan for reviving the operation. The AOC expired on 3/9/2023 and never got extended. By letter dated 26/12/2023, the Director General of Civil Aviation confirmed that no further extension was granted beyond 30/9/2023. The NCLAT by order dated 12/3/2024 granted yet another 90 days, which had also expired on 12/6/2024. And even today, respondents do not have an AOC. It is surprising the respondents contend that since the matter is under litigation, they have not renewed the AOC, which only exposes their disinterest and inclination in taking it forward. Slot allotment. The NCLT order dated 13/1/2023 by para 124 had clearly rendered a finding that there is no dispute that slots for which SRA applied were granted to them by the concerned competent authority, including slots in Delhi and Mumbai, on settling the old dues. And as such, it cannot be considered as non-allotment of slots as SRA has received the slots. It is requested for compliance with the plan approval order. Reference is made to PDF page 81 of the additional documents. This is a mail dated 27/6/2022 issued by MIRE, and the same reads as under. We are happy to consider your request for slots on parking bay during the ongoing summer schedule. The same is subject to closure of the ongoing discussions pertaining to settlement of outstanding dues of Jet Airways towards MIRE. When NCLAT had correctly recorded, when it should be NCLT, sorry, my lord. When NCLT had correctly recorded a finding that slot allotment is subject to payment of airport dues, which the respondents had not paid even today, the NCLAT by para 50 and para 55 concludes that the adjudicating authority has rightly observed that settling of old dues cannot be considered as non-allotment of slots, and therefore condition 7.6.1c stands fulfilled. This finding is contrary to the finding of NCLAT and the resolution plan, and the respondents had breached this condition precedent too. D. International traffic rights. The NCLT by para 125 had rightly held that the international traffic rights clearance is required to be obtained in compliance with the applicable laws, which stipulates that minimum 20 aircrafts are required to be deployed before applying for such clearance. After holding so, it proceeds to conclude that this condition cannot be satisfied upfront and can be done only when the operation recommences successfully, and held that this condition precedent stands fulfilled. In simple terms, NCLT has modified a condition precedent as a condition subsequent, and this view of NCLT has been upheld by the NCLAT by paragraph 56 to 58. The findings are in clear contradiction to the express stipulation in the resolution plan. 7.6.1d reads as international traffic rights clearance. The corporate debtor shall have received the international traffic rights clearance in compliance with the applicable laws. This condition again stands breached by the respondents. But before I read the prayer, we have to make only two submissions. But both yesterday and today, my friends have been repeatedly, my lord, referring to, my lord, the judges of the NCLAT. But not once we have said anything about. We are dealing only with a judgment. Not once we have uttered anything, my lord. Institutional respect will always be regarded, and we have always done it. We are dealing a judgment as a judgment. I do not know why, my lord, this is being done. Number one. But number two, the most important, my lord, this is a very defining moment in the growth of IBC law in the country, my lord. This judgment now should, my lord, set at rest some of the issues which are, my lord, IBC has done a lot of good compared to, my lord, the earlier regime. Lot of institutions and companies have been brought back to stream. All that is fine. But, my lord, it just can't be read. Some investor, my lord, for 5,000 crore investment, somebody comes casually, says, I'm a small trader, I'm a small player. And he says it after 3 years of getting into the scheme and not allowing the scheme to mature. But serious players alone should be in IBC if they are serious about it.
According to you, the grey area is after the plan is approved and when it comes to implementation of the same.
And now somebody cannot say, because one of the lenders is on an appeal, the plan comes to a halt and therefore we won't comply for years to come. And start pulling, saying we'll wait for things to happen. But it has to go on. And my lord, please suggest if there is something, if you because my lord, government also is looking for, my lord, we want to improve as much as possible. Some suggestion that we should also, my lord, from your lordships through this judgment will help us to accelerate process even within the system to do it. My lord, I'll read only the prayer class and then with that we'll wind up. Resolution.
No further arguments after him. No? Sorry.
Just one clarification.
Absolutely no.
But
No, not at all.
The
Now
resolution,
into final rejoinder.
the resolution plan has failed quite miserably, and the legal consequences therefore should follow. The appellants therefore pray A. The impugned order of the enclave dated 12/3/2024, upholding the order of NCLT dated 31/3/20 needs to be set aside. This court should therefore hold the resolution plan has failed. The appellants pray that this court should direct liquidation, invoking its power under Article 142 to save and avoid yet another round of litigation commencing from NCLT in this regard, and thus render justice. Only one sentence I may be allowed to say, because not whenever this matter gets heard, the first flash news headlines, print media or any media says government is pulling down the airline one after the other. That's the strong statement. But we are not pulling. After 2.5 years, somebody has kept the whole plan choking. What are we to do now? How are we to discover what is the alternative we have today? So we are not pulling out any airline as is being portrayed. So my lord, this is a very strong objection we'll have to necessarily take. There is no alternative after 200. How do we travel back in time? The loss of time and the loss of its proposals leads us to this. C. Direct the appropriation of 200 crores for adjustment towards various costs and adjustments and permit the invocation of bank guarantee in terms of clause 9.4 of the resolution plan read with 3.13.73 of the RFRP. D. Direct the respondents to pay the airport dues which they had admittedly considered before this court as their responsibility, which stands at 1,100 crores approximately. There has been an inordinate delay, an utter non-cooperation at every stage and right from the beginning. The respondent had no inclination to execute the plan, and valuable time of more than 2.5 years had been lost since the NCLT passed its order on 22/6/2021 approving the resolution plan. This honorable court should therefore impose huge damages for the loss of valuable and irretrievable time. Had the respondents exited 2.5 years ago, the COC would have had the chance to explore various alternatives. The respondent had choked the whole process and had acted in the most irresponsible manner. The lenders, instead of recovering its dues of 7,800 crores, have been made to incur 386.72 crores during the CIRP and are further incurring 22.6 crores on a monthly basis towards maintaining the corporate debtor. In addition, the lenders are now facing a dues of 1,100 crores from the airport authority. This is where we stand in this case of the airport. But extremely, deeply obliged for this wonderful indictment. Deeply obliged, Your Lordships.
Lordship, you have to file a submission on 1259.
So we'll just reserve judgment.
Just file a small, just 1 minute.
And we'll come back in literally 3-4 minutes.
We'll just file a small note.
Sale of the aircrafts was mentioned yesterday because it is not concerned either way it goes. So the lordships had appealed that order. That may be kept separate.
We'll just file a small note to respond to what Mr. Venkatraman has put.
Further note.
My lords, for the resolution.
What their lordships
My lords, for the resolution profession, my lord, some interim protection.
Deeply obliged.
now.
My lord, one line, my lord. Sorry, my lord. I general.
That is over. Sorry now.
My lord, the only difficulty is I'm
Say what you
collateral
want to say.
damage without hearing in this. That's all I'm not. May I just request? I will not say. My lord, this is something where your lordships have not told us yesterday that the intervention is totally different from both sides. Either ways, if it's good, would your lordship just permit? I have filed the note. If your lordship will just see that note whenever. That's the only request which I'm making.
Yes.
Very well, my lord.
My lord, similarly, on behalf of the resolution professional, my lord, some interim protection may be granted.
That we have been told. We have got the note. We look at it.
Yeah.
Right, my lord.
Grateful, my lord, and so apologies for the.
May it please go. Well, then items 8 and 9, which are dealing with the ridge issues, at a preliminary, if I can just point out that 9.1 may not actually be relevant for this, because 9.1 can be detagged and can go back, because 8, 9 and 9.2 are dealing with the southern ridge and the contempt issue and the overlap. 9.1 is dealing with the central ridge and a separate contempt issue. So that's being dealt with separately. I don't think it comes into this overlap issue. So 9.1 can be detagged.
9.1 is to be detailed.
Yes. Now,
who's for the other side?
Well, there are both amicus.
9.1 is to be detagged, no, Mr.
DDA is not in it. DDA is not in 9.1.
9.1 is not.
But I appear for DDA. DDA is not the party.
Amicus is there. Both Mr. Parmeshwar.
9.1 is to be detailed.
Can be detected. It's not concerned with this.
It deals with the rich. Yeah.
But there are two sets of amicus. I'll just give you a brief backdrop. The Godavarman case, which are largely dealing with deemed forests, is item 8. Now, in that, there are, Mr. Parmeshwar, I think, is the amicus. In the other one, Mr. Guru Krishna Kumar, Ms. Anita Shanoy, that's the MC Mehta cases. They are the amicus.
We have to deal with a limited issue.
Limited issue of that?
There was Justice Gawai was dealing with one bat.
Correct.
Justice Oak was dealing with one bat. Both the honorable judges felt that, this can be consolidated and heard by one bench.
Yes.
That's why we are dealing with that. So we are not going to, whatever is before their lordships, apart from this limited controversy, will go on before their.
There's only one thing I want to highlight, Manoj. On the ridge issue, in fact, the order passed by my Lord Justice Gawai's bench, it mentions about how ridge matters, there's an overlap between two benches. Therefore, maybe 9.1 also could be heard by one bench, Manoj, because ultimately
that's a separate issue which I'll deal with on the administrative.
Very, that's fine.
This is really on judicial orders.
As far as this overlap is concerned, I've made two distinct compilation because
which is the matter which we are going to take up. We are taking up
effectively 8 and 9. 9.2 is a suo motu criminal contempt in 9. So it's 8 and 9. 8 is Godavarman. 9 is the contempt in MC Mehta.
Okay.
So I've given two small compilations. I'm not sure if it's on your lordship's record because the actual record is too massive. It's from 85 and 95 in these two cases. So it'll be several thousand pages if you look at just the orders themselves. So just briefly, just 2 volumes. I don't know if lordships can.
May I have it?
Yes.
Because I just one submission to make. Yes. The matter arose out of certain cutting of trees in a certain part which the DDA is involved in. There was already an order passed by my Lord Justice Gawai which said that DDA shall not allot these lands until permission of the court is taken.
They shall not allot any land.
Allot any land. So DDA went ahead, allotted the land, cut the trees. Without bringing this order to the notice, they filed an application by before the other bench dealing with the
explain.
No, 1 minute. Just give me a minute.
My volumes deal with this because
just give us 1 minute.
Yes. So without bringing this order to the notice of the other court, they filed an application there for cutting of trees. That application stood rejected by my Lord Justice Oak's order. Despite having got the rejection there, they went ahead and cut the trees. So effectively, they were in contempt of 2 orders. One order passed by court number 3 and the other passed by court number 6. So when the contempt, there was a contempt petition that was filed before court number 6 and that had traveled substantial distance in the sense that affidavits were called for. Justice Oak was continuously monitoring who was responsible. So that is the merits of the controversy. I don't want to get into that on that part today. What happened to the contempt which was suo motu taken by Justice Gawai's court in court number 3? That in the order referring this matter to your lordship, Justice Gawai says, since it has traveled substantial distance in the other contempt for the same matter, we will not take any action on this. So this is the limited nature of controversy where the overlapping on the same facts has happened. Mr. Shankar Nayan probably wants to argue on a larger question as to whether it is MC Mehta or Godavarman, which of these benches must hear all matters arising out of Delhi forest, because Godavarman deals with larger forest issues. MC Mehta bench deals with specific issues relating to the Delhi ridges, south, central, and northern ridges of the Delhi, and possibly say that one of the benches must hear, but that's a larger question.
I don't know why you should guess what I'm going to say.
No.
If I can
I'm only
We
stating
confine ourselves to the limited issue
of this contempt.
of the contempt.
That's right.
Just there are effectively two contempts today. So I'll just give the backdrop of MC Mehta first and then of Godavarman, because that is relevant to decide this issue. So if you see MC Mehta, this is W4677 of 85.
What is this?
Just the relevant documents for, I have a separate compilation for Godavarman, this one for MC Mehta. So this is just the orders and the CEC reports, that's all. So one small backdrop, the two petitions of 1985, Malods, both by MC Mehta. One is the air pollution matter, which in fact was listed today before Justice Oka's bench. The other is the one which is here, which was dealing with sealing issues and several issues in association with that, which included and expanded into Haryana mining, sewage issues, whole series of orders from 1985 in that batch, which your lordship will recall, there were a whole bunch of sealing issues which arose in the 2000s, etc. Now there is a central empowered committee, which is the CEC, which from time to time gives reports in both this case as well as 10 years later, the Godavarman Thirumalpad case, which dealt with deemed forest. Now that deemed forest issue is an all India issue. So several issues have come from across the country and the CEC gives reports there as well. There are different sets of amicus in this matter and in that matter, in both these matters. It's normally been going on CEC reports and then the court passes certain orders. Applications are filed by different individuals at various points of time. They want clearance of a project or something else. MC Mehta, these two 1985 cases are exclusive to Delhi and the NCR. They don't expand beyond that. It's Delhi and the NCR. I hope I'm making myself clear. Now, one of those two MC Mehta cases, this 4677. Now, in this, Manoj, there's this first document is 9/5/1996.
Let's go to the, instead of expanding the broad ambit, let's go to what the actual contempt was.
The actual contempt is this.
We don't have to spend the whole day.
The actual, or just give me a minute. Let me just finish. The actual contempt is simply this.
Let's get to the orders of which there's a contempt.
I'm right now getting to that. So in this, in MC Mehta, there are two orders.
You confined to the contempt.
No, I'm coming to that. Just give me a minute. If you'll give me 3 minutes, I'll finish the whole thing. 3 minutes. In MC Mehta, there are two orders of which there is an allegation of contempt. We filed the contempt petition. Effectively, what happened is this. There is an entire part of land which is held by DDA. So it's DDA's land. Therefore, there's no allotment of by DDA to somebody else. It's their own land. Now, on that DDA land, there was a project expansion plan to widen a road. So, widening the road led to two things. A whole bunch of chopping of trees, which were all standing there on that DDA land. Now, what DDA did is they filed an application in this MC Mehta case where they had to get clearances because it covers rich land. They came and filed an application in March of this year. The application was dismissed as withdrawn, saying, look, you have given no details about the number of trees, what this project is for, is there other ameliorative plans, etc. What DDA had not told the court when they were standing there and pressing that application was that they'd already cut the trees. 2 weeks earlier, in the middle of February, all the trees were gone. Lock, chop, and timber all disappeared. Almost about 1,200 and something. About 1,100 trees were cut. Now, the contempt happens of two orders here. The first order is one which said you will maintain the ridge in pristine glory. You will try and ensure that fauna, flora, etc. is restored because we've seen a coach and four being run through for mining, for development plans, etc. That's the first order. The second order is this order of March 24, which is number 3 here, serial number 3, 4th March 24, which specifically permitted them to withdraw their application and said you make a fresh application with all the details, not knowing that they had in fact they had already cut the
So now let's go to that.
So
let's focus on what the contempt, what are the orders and what's the contempt.
So in just one additional,
then we will have to see how the contempt has to be purged, assuming there's a contempt.
No, but I must tell you this. Prior to this,
we don't want another jet airways on this. We'll fix this up as quickly as possible.
I'll keep it brief, Malad. I always get squeezed being a tail ender. So I'll just tell you, in the other matter, in the Godavarman matter, there is an order, which is what Mr. Parmeshwar was referring to, which says that there will be no, this isn't from 2023, which says that there will be no diversion by DDA of land to others, right? On the morphological ridge. A morphological ridge is one which has ridge-like features. Now, technically, the DDA could say that we didn't divert our land to anybody else. We still hold the land. We lopped trees on our land. Now, regarding that, so there is no, in my view, I may be wrong, in my view, I don't see a contempt of any order which is there in Godavarman in that. I don't see that. But prior to the contempt petition being taken notice of in MC Mehta, of those two orders, in Godavarman, the CEC filed a report saying we have received a complaint from someone. That complaint shows that there has been a violation of both Godavarman and of MC Mehta. So CEC, which is a common CEC for both matters.
Now let's see the order, because we'll be able to focus on what's happening.
Just come to the other then. You also want to see the orders here. The first order that is relevant
is actually, which is the contempt petition that we are hearing. Let's start with starters.
So the contempt petition is here in MC Mehta.
Yes.
That, just please come to page.
So we are dealing with writ petition civil 4677. What?
Yes, my lord. One second, my lord. Both in the contempt and in the
when your turn comes, you can give it.
Miscellaneous application of contempt petition number 21171 of 20.
Yes, it's item 9. That's a contempt petition.
Contempt petition number 21171 of 2024.
That's right.
So should we go to page 91?
I put the documents here itself in this.
We got it in the order. This has been given.
Yes. Yes. Page 91.
This was the first order?
The order of which contempt is claimed below, there are two orders. One is dated 9/5/1996. In this compilation that I've given your lordships, it is the relevant part is at page 4, bottom of part 4, page 4. Yes, I'm giving both. So, just one sentence I'm going to read from the ecological balance to be maintained. Your lordships have page 4, bottom.
In this?
Yes, in this page 4.
Or in
the highlighted part. It's just, I think it's the same thing, Manoj. It's the same. If it says MC Mehta, then it's the same.
Page 4.
Yes, page 4.
Got it.
Yes. If you see it on the screen, it's the highlighted portion in yellow.
Yes, got it.
No further infringements. This is in the extracted portion of the master plan. No further infringements of the ridge is to be permitted. It should be maintained in its pristine glory.
Where is this?
This is page 4 of that compilation, Manoj.
Yes.
It's on your screen as well. So that highlighted portion.
Yes, no further.
Yes. So this is part of the order dated 9th May 1996. So no further infringements of the ridge is to be permitted. It should be maintained in its pristine glory. And the next page, page 5, after the extract. The provisions of the master plan make it mandatory that the ridge is to be kept free from encroachers and its pristine glory must be maintained for all times. It is a pity that neither the central government, etc., etc. Now, this is order number 1. The second order is at page 33 at 44. This is dated 4th March 24. Five your lordships have. Both March 24. Lordship may just notice one small thing. 16/2/24 is the date on which apparently the tree felling started. That's not here, but it's part of the affidavit and it's been recorded by your lordships in a subsequent order where the DDA says that we cut the trees starting 16th Feb 2024. So this is after 16th February. So on 4th March 2024, there is this IA 40494, which is the DDA's IA.
So this was an order passed in the contempt petition.
No,
in
before the
MC Mehta.
No, this is before the contempt.
No,
So-
this order 4th of March.
No, this is what is the second order of which there has been a contempt.
Okay.
So
Which
the
is
first is
order?
96.
96.
First is 96. Second is this at page 45.
Page?
45.
Hold it.
Same compilation, page 45. I'm just showing you the relevant part. It's on the screen, Mala. IA 40494. This is dated 4th March 24.
1 second. Where does it begin?
It starts at 33. 33.
4th March 24.
Yes, 4th March 24.
Page 33.
Yes, it starts at 33, Manoj.
At
45. At 45.
Right.
Now, because they deal application wise at 45, just above para 10, your lordship sees IA 40494.
Yes.
That is the DDA's IA. Having suppressed the fact that the trees have already been cut, seeking permission to cut the trees after the trees are cut. Now, here, your lordships see at para 11, apart from the fact that the application is very vague, which seeks permission to fell, translocate 1051 trees, we must note that the DDA is an agency and instrumentality of the state.
Where are you reading?
I'm sorry,
Page 45.
bottom of page 45. No?
Para 10.
Yes, this is para 11 now.
I got it.
Yes. That IA 40494, Manoj, just above para 10 is the DDA's IA for permission to cut trees. So it's noted in para 11 and they continue to say, therefore it is the duty of the DDA to first make an attempt to protect the environment by praying for felling of only those trees which are absolutely mandatory. They must apply their mind whether alternatives can be examined to save the trees. Moreover, they want to construct the road through a forest. There is no permission obtained under the Forest Act. We direct the DDA to re-examine the proposal by employing the experts in the field. The exercise to be undertaken by the DDA is necessary for ensuring that while public work is carried out, minimum number of trees are required to be felled. The said approach is not reflected from the application made by the DDA. After the DDA re-examines the proposal with the help of eminent experts in the field, we permit the DDA to file a fresh application for the same relief, hopefully containing a prayer for felling of much less number of trees. With liberty as above, the application is dismissed. Now, in sequence, what happens after this is that it comes to light that in fact these trees were already chopped much before DDA made this application. So it amounts, in our view, as contempt petitioners, that it's a violation of both these orders in the MCA Mehta batch. Because on the ridge, the pristine glory has been completely eroded if you have chopped these trees. Plus, you have had the temerity to come and make an application to the court for permission to cut the very trees which you have already cut. Now, while the contempt petition had not yet been filed, the CEC takes note of this complaint in a report dated 22nd April 2024. This starts at page 47, same volume. Refers to a complaint of one Mr. Naresh Chowdhury at 51. 47 at 51. Now, this report, Manoj, is filed in Godavarman. It's not filed here in Mehta. So the cover page at 48 shows that the report 4 of 24 in writ petition 202 of 95, which is Godavarman. That's at 48. And then the report starts at 51. I won't read the whole report, but there's a complaint and the broad description is there at page 52. Your Lordships, bottom of 51, beginning of 52, by way of the present application. I'm sorry, do my lords have it?
Yes.
Yes. By way of the present application, kind attention is drawn to the illegal activities which are rampant near South University. applicant is alleged that some unknown contractors with active help of officials of Delhi government are constructing a road near the Sark University. Said road is Gaushala Road, etc., etc. And it's been going on without Forest Act permission, and it's been going on the Delhi Ridge. Now, your Lordship can skip the rest of it till page 55 bottom, para 5. Para 5. Furthermore, in the extant case, the DDA also required leave of this Honourable Court before start of work as per directions passed in MC Mehta, and has consequently filed an IA number so and so. The Honourable Court has dismissed this on 4th March. So there's a reference to Mehta here, fully Mehta's order. And then para 6. Despite the above clear-cut orders, several trees have been cut on the land under care of DDA and also on the southern ridge, which is reserve forest land. Moreover, construction has also been started. And then, Manoj, the directions which are solicited at the end, which is recommendations of the CEC at page 65 and 66. So the CEC's report submitted in Godavarman notes the violation in Mehta. And the recommendation of the CEC, para 16, at 66, it says the central government may consider initiating actions under provision of section 3B of the Forest Act against concerned officers, etc., etc. And action as per the relevant penal provisions of the Delhi Protection of Trees may also be initiated against the concerned officers. And 3, the court may consider the issue of violation of its orders dated 8th February in Godavarman. Your Lordship, please note this, page 66, bottom, last 2. That the court may consider violation of 8th February 2023 in Godavarman and 4th March 24 in MC Mehta. Now, on this, Manoj, the contempt petition is filed by us. If your Lordship want to go in sequence, there is a separate compilation dealing with Godavarman, which shows those 2 Godavarman orders, the order of which contempt is claimed and the order in sequence of time. My Lord Justice Gawai's bench was pleased to take note of that report. So there, Manoj, just if you can come to page 24 of the other compilation, the Godavarman one. That's the order of 8th February 23. This is at page 24. At page 39, Manoj. More pages are devoted in these orders to our appearances than to the orders themselves. At page 39, has that at the bottom, that IA 191635. This was an application concerning the permission for diversion of 6,200 square meters. I'll just take you to the relevant part of it, which is at page 43, the absolute last para of under that application, page 43. After appointing a committee to decide on the modalities of the morphological ridge and what it means, page 43, para 18, we further direct that until further orders.
So here the CEC had permitted the setting up of the office of the DRN.
Correct.
Yeah, that's right.
Correct.
Yeah, the Revenue Intelligence Department. But what was observed at the time of that hearing was the fact that DDA has been allotting these lands without taking the permission of this court. So this court thought it fit that until and unless there is explicit permission of the court, these lands must not be further allotted.
Yes.
Lands which have morphological like features.
So at para 18,
this is the 8th February order.
Yes, 23. Last year.
Come to page 41.
41, yes.
Read the last paragraph.
Para 8 months or 7?
It refers to the report of CEC dated 1st December 2022 wherein it is said, this honorable court may consider directing the DDA not to allot in future any land to any agency situated. Now there are two words, notified reach and morphological reach.
Yes.
We are concerned with these two regions so far as the contempt is concerned.
We are concerned with the slightly broader phrase used at the end of the order.
Page?
Which is at page 43.
43.
Page 43, para 18. Which takes what your lordship said into consideration.
Any land in there.
Yes. That DDA shall not allot any land in the areas which are under consideration. So the areas under consideration are, your lordships are right, including all of the areas which are being considered as morphological reach, for which they've set up a committee.
Notified reach and the morphological.
Yes. Okay. So, but the critical part here is DDA shall not allot any land. So, if it is on their own land, without allotting it, if they carry out an activity, the question would be, would that fall foul of this direction? Would it be a contempt if DDA on its own land, without allotting it to anybody else, carries out an activity which is a violation of MC Mehta's order? Right. So this is the operative part. So when the CEC files that report, Manoj, in April, CEC says that the action of cutting of the trees is a violation of this order in Godavardhan and the March order in Mehta, where you took an application and then you withdrew it after you cut the trees. So to effectively today unravel this entire overlap issue, your lordship may have to consider if it is a contempt of both the orders or of only one order. If it's an overlap of both, if there is contempt of both orders, then it will have to be some solution that your lordships can find of having both benches together or something. But if it is not, and if it's really only a contempt of those two orders in Mehta, not this sentence in Godavarman, then it may not be a Godavarman matter effectively. Really, I mean, there's much more, but I don't think I have to say anything further. That's effectively what it is. But I want to show your lordships the orders which were passed in both matters. So if your lordship will see after this, when
there were
CEC
two orders. One order passed by Justice Gavai and Justice Vikramnath on 8th of February 2023.
Correct.
Which was in Godavarman.
Which is in Godavarman.
And yes. And then the second of 4th of March 2024 by Justice Oak and Justice Buyan.
Yes.
That was in MC Mehta.
Yes.
Where they dismissed the application by DDA seeking permission to fell trees on the ground that the application was vague. They gave them liberty to file a fresh application after appointing an expert committee.
So the act of two acts, Manoj, one which violates the 96
order basically said don't allot any land to any party.
Correct. Correct. So now the Mehta orders, there are two orders. One is the 96 order, which said retain pristine nature.
And you have 6 order that maintain the pristine, the region, the pristine condition.
Correct. So that is the act of cutting of the trees. The 24 March 24 order is where you suppress from the court that you've already cut the trees and you're coming here. If your lordships had allowed that application, for example, and said go ahead, cut the trees, when they'd already cut the trees, that would amount to the contempt, the fact that they'd suppressed it. So there are two orders in Mehta. Now, because the CEC report was filed in Godavarman, the order in Godavarman, your lordships may see, because that was prior in time. That's 24th April 2024 at page 78 of the same volume.
17?
It's page 78. 24th April 24 at page 92. Bottom of page 92. This is 24th April 24. It says IA 98622 within bracket CEC report number 4 of 24. I've shown your lordship CEC report number 4. So taking that report up, this is my Lord Justice Gavai's bench in Godavarman. Which says the page 92, bottom of page 92. Prima facie, My lords have it.
Got it.
Prima facie, we find that the action of the DDA in felling the trees and constructing the road is in contempt of the orders passed by this court dated 8th Feb 23, which is the Godavarman order, and also the order dated 4th March 24, which is the Mehta order. Issued notice to so and so, etc., calling upon to show cause as to why an action for committing contempt, etc., etc., be taken. 3. The registrar shall ensure that the notice be served upon Vice Chairman DDA. And then it's listed on a later date.
Right.
Now, this comes up only nominally sometime in May and then comes up properly on 24th July 24. Now, in between these two dates, between April and July, the other court has taken cognizance of our contempt petition, which is item 9 here, and issued notice, given returnable dates. The DDA vice chairman appears. The suo motu contempt is also taken, criminal contempt separately, which is item 9.2. And several orders are passed in that, between these two. So in July, if you just to complete the loop.
Tell the other bench that, look, Justice Gavai is already issued.
It was informed. It was informed. Yes.
It was one matter is also pending in Delhi High Court.
This
was also, my lord, put in the affidavit file.
Correct. So because these matters were pending here, the Delhi High Court has pretty much not proceeded. But what happened is when it was pointed out there, the bench said, look, it's a violation of the matter that I'm dealing with, which is MC Mehta's 2 orders. So I'm taking cognizance of that separately, apart from whatever Godavarman may be, because the same act has the effect perhaps of violating 2 orders. So
we'll go to the heart of the contempt. We've seen the orders now.
Yes. Now, in the contempt, the Lordship may see it's in the other volume. We have the Mehta volume. The first order is 9th May 2024, which is at page 83 of that. Page 83, my lords have it, and that Mehta volume. Yes. Issue notice in the contempt petition, returnable on 14th May 24. We direct that the respondents shall not indulge in any further tree felling, and status quo as of today shall be maintained in respect of the property subject matter of these contempt petitions at 84. Then at 85, my lords, from 9th May it goes to 14th May. And on 14th May, the vice chairman appears before the court. So that's page 86. Can I read that?
Yes.
Page 86. This is dated 14th May. Shri Panda, Vice Chairman DDA, appears before the court and accepts that not only the trees on the land vesting in the DDA were felled, but even the trees on the area of forest were felled. So there's an admission by them. We direct so-and-so to file his personal affidavit on the restoration measures which he proposes to take. Prima facie, this conduct may amount to criminal contempt, which is in addition. However, we will pass appropriate order in this regard on the next day, list on so-and-so. We expect Sri Panda to come out with at least approximate figures of trees felled and names of officers of DDA who authorized felling of trees. He will also tell us the names of officers who permitted the contractor to fell trees. He will also point out when the process of felling of trees commenced. Affidavit shall be filed by 16th May. Personal presence mandatory. The other contempt petition, which is there below, 21740, is the one that I've requested detagging of. That's 9.1, which is dealing with the Central Ridge. It's a different issue. It doesn't overlap. There's no question of this coming in the Godavarman matter. Then page 88 is the 14th May order.
Same day.
No, for the earlier one.
That is
no, I don't know. But it's been put twice. I'm sorry. 16th May, page 91.
All right. Then
14th May, I'm sorry.
16th May.
16th May, page 91. The This is a fairly detailed order, if I can read that. This court noted a very shocking state of affairs while passing the order dated 14th May. We have noted the conduct of the DDA of felling a large number of trees without any authority of law and in breach of the orders of this court. After perusing the affidavit filed by the Vice Chairman, we have realized that the situation is far more serious than that we understood on 14th May. The conduct of DDA of the felling of more than 1100 trees without the permission of the court shocks the conscience of the court. An application was made by the DDA, being IA so-and-so, in writ petition 4677. The prayer in the said application was for the grant of permission for felling trees for the construction of Gaushala Road from Chhatterjee to Sark, etc. The application was supported by a recommendation of the CEC. The recommendation was to permit felling of a large number of trees. On 4th March 24, when the application came up for hearing before this court, we passed the following order, and that order is extracted, the 4th March order. Therefore, when the application was heard in support of the prayer of the DDA seeking permission to fell translocate 1051 trees, the learned counsel representing the DDA proceeded on the footing that not a single tree has been felled. A shocking disclosure has been made in para 7.1 of the DDA's affidavit filed by the Vice Chairman, which read thus: I respectfully submit that I have inquired from the officials and employees of the DDA and have found that tree felling apparently started on 16th February 24, which is the date I gave you earlier, as per their verbal submissions, and continued for about 10 days. The IA in writ petition 4677 had been filed before this honorable court on 15th February. So they filed the IA on 15th, on 16th they start chopping. It is also submitted that even when the application was disposed of via order dated 4th March, the felling of trees was not in the knowledge. It's not clear whose knowledge. The honorable court via its order dated 4th March has given the following directions, and that extract again. It is submitted that in compliance with the said direction, DDA had initiated action and proposed constitution of a committee of eminent experts in the field so as to minimize the number of trees required to be felled. Proposal has been duly approved, which shows bona fide efforts, etc., etc. Paragraph 4. The shocking admission by the DDA is that the application we referred to earlier was filed on 15th Feb by the DDA, and brazenly the DDA started felling trees on 16th February. The affidavit also notes that the felling of trees continued for 10 days, which means that by 26th February, whatever number of trees required to be felled by the DDA were already felled and destructed. When this court heard the application on 4th March, the DDA suppressed this material fact. The DDA was fully aware that without permission from this court, not a single tree could be touched, and therefore the application for permission to fell 1051 trees was made. By completely violating the law and orders of this court pending the application, the work of felling trees was started and was completed. This shows that the DDA has committed a willful breach of the directions issued by this court on not undertaking the felling of trees without seeking permission from this court. Moreover, DDA was aware of the requirement to obtain permission from this court, and therefore the application was made. The dishonesty does not end here. In para 7.2, it is stated that based on the observations of this court and the order dated 4th March, an action of constitution of a committee of eminent experts was initiated to minimize the number of trees required to be felled. It is stated that this proposal duly approved on 12th April 2024 by the Honorable LG in his capacity as chairman of DDA. Therefore, the highest authority of Delhi, the Honorable LG, was also misled by taking his approval on the proposal based on the observations made by this court while disposing of the application. Though approval of the proposal of Honorable LG is relied upon, the Vice Chairman of DDA has chosen to withhold the said document from this court. We direct the DDA's Vice Chairman to produce the document on record. We also direct the Vice Chairman to personally address a letter to the Honorable LG, pointing out that while forwarding the proposal to him, which is referred to in para 7.2, the material fact that felling of trees was already complete was suppressed. We hope and trust that the Honorable LG will take this issue very seriously, not only in his capacity as the LG, but also in his capacity as Chairman of DDA. As narrated earlier, felling trees without seeking permission from this court is a willful breach of the orders passed by this court. Not only that, the conduct of starting the work of felling the trees and completing the same even before the application could come up before this court, and the conduct of suppressing this material fact from the court when the application was heard on 4th March amounts to interference with the due course of judicial proceedings. It amounts to interference and obstruction of the administration of justice. We have already issued a show cause notice for civil contempt on this contempt petition. We issue a suo motu notice of criminal contempt to the Vice Chairman of DDA. This is 9.2. In the reply filed to the civil contempt, the Vice Chairman stated that he was on leave from 16th February to 2nd March 24, and he resumed work from home with effect from 2nd March 24. At this stage, the said defense cannot be considered it will have to be considered at a later stage. Therefore, assuming that the Vice Chairman has some defense available, we expect him to disclose the names of all the officers responsible for violating the order of this court and the suppression of facts so that we can issue notices to all those officers. We are not prepared to believe that the contractor entrusted with the work of widening the road has indulged in cutting trees of his own volition. Obviously, it has to be on the basis of the instructions from the officers of DDA. Para 9 of the affidavit of DDA is material, which reads thus, and it talks about the contractor, etc., and the bidding that was done for that. Then, if I can skip on to para 9, my lords. After what transpired in the court on the last date, we expected the DDA to devise a time-bound schedule for restoring the wrong done. Considering the extent of destruction, it is evident that in the true sense, there cannot be restoration of the damage caused to the environment, as newly planted trees will take years to fully grow. Instead of coming out with a time-bound schedule in para 5 of the affidavit, the Vice Chairman of the DDA has come out with very vague statements. The orally we are informed across the bar that the road has not been constructed on the sites on which the tree were felled. Para 5.1 of the affidavit shows that the work has been carried out, and therefore the Vice Chairman is talking about the restoration of a stretch of land. Even the correct information about the construction of a road on the site is not provided to this court, though the Vice Chairman has filed a very long affidavit. Then they come to the number of trees, etc. You lordships can see the numbers that they have referred to. 174 on DDA private land, 629 on forest land, 458 trees have been cut, 258 on DDA private, and 161 are still standing. A report of the... Then para 11, however, our attention was invited to an order of the Delhi High Court, in which it is recorded that the DDA itself stated that about 1100 trees have been felled for the same project. The figures given in para 7.5 are inconsistent with those in the table incorporated in para 16 of the affidavit. The long and short of the discussion is that even while responding to the contempt notice, the DDA has not come clean with all the factual aspects. Though an unconditional apology has been tendered in the first para of the affidavit, we find that looking at the other paras in the affidavit, the apology is only by way of rendering lip service. Otherwise, a positive statement would have been made that the restoration work would be undertaken immediately. However, that has not been done. Para 13, the direct stopping of all activities, etc. And 14, they say that an independent agency must be appointed and that restoration measures will be taken up. So at 15, para 15, which is at the bottom of page 99, they appoint such a committee. Now, this includes Mr. Ishwar Singh, Sunil Limaye, and Pradeep Kishan, of course, a well-known author and the Forest Survey of India to guide this. This is regarding number of trees. And they've given directions at para 18 as far as the committee is concerned, and then asked for all the documents to be clearly placed before the court regarding this. Give me the dates, just give me the dates on this.
Now, did the Forest Survey submit a report on the work of restoration which is required to be done?
An interim report has been submitted. The restoration work is going on. Several trees have been planted. That work is on its way. So effectively, that road issue is now perhaps moot with reference to extension because the trees are all being replanted. Most of them. The work is almost complete, is what I understand. After this order, which I've read to your lordships, there were further orders, 5 orders of 24th June, 26th June, 9th June, 9th July, 10th July, and 12th July. So I'll just repeat those dates. 24th June, 26th June, 9th, 10th, and 12th July. Which took this further. They're all fairly extensive. They've gone into reports, replies, etc., etc. After which, Manoj, 24th July, the Godavarman matter is taken up. And that's when this issue comes up over the overlap. So please see that. It's in that Godavarman file. 24th July. It's at page 94 of it. Relevant part is at 107. You should. It's much bigger so they know which one. Yes. page 107, my lords, of that Godavarman volume. My lords have it?
Yes, God.
So this is 24th July, which is what has led us here. This court in the present proceedings has been monitoring the issue with regard to grant of permission to allotment of plots, please note, in the larger public interest in the area which is not yet notified as a protected area in the Delhi Ridge. The bench presided over by one of us had passed an order on 8th January directing the DDA not to allot the plots in the areas that were not yet been notified as protected areas. It appears that in violation of the orders passed by this court, the DDA had allotted the land for expansion of the road. That's not correct. They had actually chopped the trees themselves. Allotted the land for expansion of the road and also permitted felling of the trees on the said land. Finding that the action was contemptuous in nature, we passed the following order. That's a 24th April order. It appears that in the parallel proceedings in Arbitration so-and-so, Mehta, the DDA had moved an application before the bench presided over by Honorable Justice Oka for seeking permission to fell the trees on the said land. The application filed by the DDA was rejected on 4th March. The bench presided over by Justice Oak also initiated contempt proceedings with an order dated 9th May 24. As such, a situation has arisen wherein for the same cause of action, 2 contempt proceedings are pending. One on basis of notice issued on 24th April by the bench presided over by one of us, and the other on the basis of the order dated 9th May, which was passed by the bench presided over Honorable Justice Oak. Mr. Parmeshwar Learned Amicus informs us that the contempt of proceedings initiated by the bench presided over by Honorable Justice Oak has substantially travelled and various orders have been passed by the said bench. We are of the considered view that the continuation of 2 contempt proceedings for the same cause of action would not be in consonance with the judicial propriety and interests of justice. We therefore direct that the contempt proceedings initiated by the bench presided over by one of us, vide order dated 24th April, are kept in abeyance. Now, I can skip on to para 10.
The road has been constructed, or what is the position?
No, Manoj, because they cleared it for asphalting. Mr. Adrian Rao, who's amicus, had shown the photo of the constructed as little bit of asphalting that has been done to the court. It's taken note of by the MC Mehta bench, and then they say give us a restoration plan. Restoration plan is furnished.
Therefore, my lord, Justice Gavai said that let the papers be placed before the Chief Justice. It's desirable that both are heard by the same.
So that there is no.
Because there were 2 parallel proceedings, one with regard to the MC Mehta order and one in regard to.
Correct. So that's the background.
Now, we come back after lunch. Tell us now what about the way forward.
Very well. Very well.
What brings you, Mr. Tripathi?
Item 32 today was pursuant to an email request for for mentioning, which was allowed. There only it's from Andhra Pradesh, only a new arbitrator has to be appointed. Unfortunately, Justice Devinder
item number 32
and therefore the arbitration has come to a standstill. It should not take more than 2 minutes.
Okay, before we rise, who's for the other side though?
We have informed.
My lords, I am for the petitioner. My lord, this is the petition only for 29A. We have instructions to withdraw this petition, my lords.
Well, I want it. There is no arbitration going
Because I am the petitioner, I have instructions to withdraw this petition. This is only with respect to 29A because it has now been filed in the district court and appointment of arbitrator application is also filed in the High Court, which is coming up day after tomorrow.
We'll take it up at about 4:45 or so.
Whatever.
We'll take it about 3:30 after.
3:30.
Or better still, how long would you take? About 10 minutes now?
2 minutes.
All right. And your side?
I think the question is, they have to answer.
Mr. Interesting, you have to do a lot of answering about how you have done all this. You are the
utmost respect, not all facts were placed before Honorable Mr. Justice Oka in the subsequent orders. I'll just show those orders.
Okay. We'll take this up after this matter gets over.
Very well.
I had one request. There are 2 judicial officers matters pending. The other matter might take some time. But so far as the High Court judges are concerned, they have now, this entry is now taken a stand. That might not take more than 15-20 minutes. They are saying that judges who are elevated to the High Court from the district judiciary are not entitled to Provident Fund. So then that I am saying, if your lordship just consider it about 15-20 minutes anytime.
Just remind us after we can do that. We'll give that special listing for some, because there are High Court judges who are not getting their Provident.
My lords, marital rape, my lords had said.
So sorry to keep you waiting. I had some urgent meetings which just dragged on after lunch actually.
Lordship, I beg to mention item 34, Lordship. There is an urgency, medical college admission related matter.
All right, I'll bear it in mind. Not today, we'll take it up tomorrow.
18th is the...
I'll make sure that we hear it before that. If not today, tomorrow we'll, or the after we'll take it up. Don't worry.
Maybe...
Yaad dila do. Fresh matter. Is it on board?
Mic.
MA.
Huh?
MA is.
MA, you handle it with the registry.
Yes, but sir, core issues matter. Core issue is termination of service. Service matter is.
Right. MA, they will handle it. MA means your main matter has been dismissed.
Okay, sir, but sir, I filed a fresh and independent fresh petition, but registry.
Come in the morning. Don't disturb the court at 2 o'clock. Come in the morning. Yes.
Well, so in the Mehta matters,
yes,
in the Mehta matter, there were 3 further orders.
Yes.
Until this July order that came in the government matter. They're fairly lengthy. I'm just telling you what took place in those 3 orders. 24th June is the first of those. This is after the May order. 24th June. 3 significant things in 24th June. That's not in those compilations. Yes. So you'll possibly have to take the main paper book, which is online.
What happened on 24th June?
24th June, 3 things are noted. It's a very long order. It notes 3 things. One, there are 3 emails which are sent by an executive engineer, which is sent to his colleagues in DDA, sent to his colleagues as well as to the contractor, all recording the fact that in fact it's on the instructions of the Lieutenant Governor, who is the chairman of the DDA also, on his instructions that the tree cutting took place. So he was asked to, the DDA was asked to give details as to when the meeting took place, who were all present, etc. And on what basis this man has sent these emails. This man, the executive engineer, says my email was hacked and therefore this is not actually an email that I sent. So, the court obviously frowns on that kind of an explanation, but that is one. The second is that the court observes that there are subordinate officers being used as scapegoats because such a big decision couldn't have been taken at their levels. And the third, which was very shocking, was that in their affidavit, the DDA said that Delhi judicial officers were acting as advisors to the DDA. So the court notes that this is shocking. How can sitting judicial officers of Delhi be on deputation with DDA to act as legal advisors to DDA, your judges? So court directs, requests the Delhi High Court to take action in this regard and says this situation can't continue. And the acting Chief Justice of the Delhi High Court then takes steps, and from what I understand, that position doesn't continue. That's 24th June. That's the first. The second is 26th June, where the court says that many questions that we have placed don't have answers either from DDA or from the Delhi government. They give detailed directions to restore the ridge area, the entire area where the trees were chopped, etc. And also says that in the main matter, in the main MC Mehta matter, that the committee which has already been appointed, that committee which with the Forest Institute, that committee of experts will now be in the main matter and they will file reports with reference to all these issues that have arisen and will continue to be monitoring things. Finally, on the 12th of July, Manoj, detailed directions are given where they accept finally, the words used is the truth is finally out. And they note the number of individuals who are present at that meeting of the LG. This was a 3rd February meeting prior to the cutting when the LG apparently conducted a site visit. And the presence of all of them at the meeting is listed. And the Delhi government is asked to give details of what steps have been taken against the officers. And the Delhi government also records that
if the Lieutenant Governor was advised that there is a status quo order of the Supreme Court,
yes,
it's unlikely that he would have said that there should be a violation of the order of the Supreme Court.
Yes, I don't believe that.
And the point is, who suppress these orders from the Lieutenant Governor.
That's what the court notes. The court notes that we need to get to the root of this because it's not possible with 8 officers there that nobody had a clue about these orders, etc., etc. And then finally, Manoj, Delhi government says that they have withdrawn the permission that they had granted for whether they are in a position to grant any permissions at all is moot, but they had granted permission. They record that they've withdrawn that permission now. That statement made on behalf of the Delhi government is record. Now, one last thing, Manoj, which is actually fairly shocking. There's an affidavit of 15th May, which is filed by the DDA, where they say that now we are not undertaking this project. There is not going to be any road widening. This is 15th May. The DDA files this affidavit in the Mehta matter. So this is taken on record and the court gives detailed directions on restoration, etc., etc. 15th May, this is done. On 24th of July, and that's how my Lord Justice Gawai, when he was seized of the matter, if your Lordship saw that order, there is a paragraph where this, via the same AOR, but through another council, DDA stands up and says, we want to proceed with the project. We have spent 2,000 crores on it, etc. And it's reported in the papers also, shockingly. The fact that you can go in one court, file an affidavit and say that, look, we are not proceeding with the project. We are not going to go ahead with road widening. And then very truly, in the truest sense of the word, bench hunt by going to another bench and saying exactly the opposite and say, I've spent 2,000 crores, I want to go ahead with the project. And it's not, the affidavit is not disclosed. The fact that there I filed this affidavit, we're taking restoration measures, but here I've spent 2,000 crores. I mean, this is shocking behavior by a public authority. We do not anticipate that. Now, this is the background regarding the way forward. There's, in my view, 2 ways forward. I understand this is, unless your Lordships are taking up the contempt, then there's no issue. But if your Lordships are looking at how to resolve this overlap issue between 2 benches, one suggestion that I have is...
Now we are taking up the contempt itself.
No, so then I'll go through the entire contempt and go through all aspects of it. Because in the contempt, I'll have to show you what the various violations are. Timber has gone missing. All those issues are recorded in the previous orders. I thought when you suggested way forward, your Lordship was suggesting about possibly assigning it to a particular bench or something like that.
That I would have done on the administrative side.
Yes,
now, both the benches felt.
But I mean, just to.
Therefore, we have placed it now before a combination of 3 judges.
Very
good. Both.
Then I'll just keep this brief. On the contempt, I'll let them respond also. Notices have gone now to many officers in the DDA. It has gone to the vice chairman of the DDA. It has gone to the chairman of the DDA, not formally. It's been recorded that somebody is appearing on behalf of the Lieutenant Governor and the AOR has been asked to be brought on record and then they will take whatever steps they need to. But there's no formal notice of contempt there. From everything that we can see from all these orders and the multifarious affidavits that have been filed, there has been a great hesitation in coming out with the actual facts as to how and why this chopping happened and how it could be that when you file an affidavit solemnly in the Supreme Court of India, you can allow your lawyers and the officers there to expose themselves to charges of contempt by not letting it be known that we have actually cut all the trees. At every stage, the court has found, this is not us saying it now because the court has recorded it, there's been obfuscation repeatedly. For example, the timber, all the trees were cut. Now, where did the timber go? The contractor is asked by way virtue of the previous order to file an affidavit saying, where did you take the timber? The contractor says, I left the timber lying right there. As per some directive of the DDA, I'm supposed to leave the timber lying right there. It's up to a height of 50 meters. Whether it's been tagged, whether it's been marked, all of this has come from previous orders of the court that you need to geotag, you need to also put numbers, you need to have a census carried out. All of this, whether it's been followed or not, nothing has come clean. It's also not clear as to what was the chain of command on the basis of which these decisions were taken, or again obfuscated. And at each time, there has been more and more affidavits that have been filed trying to explain away this issue. Now, if your lordship will then just for a few minutes take those three orders, because if it is the, I just want to show your lordship. The first one is 24th June 2024. In the main paper book, which is online now, the main paper book is a massive one. That one, I think it's PDF 67 is where your lordship will find it. That's the same volume. It's a joint volume. Orders. Orders.
9.
Orders.
Item 9.
No, it's not. Order dated 24th June 24.
Which
Item
matter was that passed in?
Item 9, Manoj. Item 9.
Let me find it.
In
Yes.
serial number in the bookmarks, it will be serial number 5.
Yes, we got it.
Yeah, Lordship. That is 24th June, Manoj. If I can just read that. We have perused our earlier orders.
Yes.
We perused our earlier orders and the affidavit filed by the Vice Chairman of the DDA on 19th June for reporting compliance with our orders. The Vice Chairman has relied upon a report of the Inquiry Committee constituted to inquire into the entire episode of felling of a large number of trees in violation of the orders of this court. In the inquiry report, an email dated 7th February and 2 emails of the same date, that is dated 14th February, purporting to direct the contractor to start the work of felling of trees had been referred. The executive engineer, who is supposed to be the author of the emails, has denied having sent the emails. The 3 emails contain a specific statement that the Honorable LG, who is the chairperson of DDA, visited the site on 3rd February 24 and directed to clear the trees coming in the right of way. Right of way. ROW is right of way. When we repeatedly made a query to the learned senior counsel representing the Vice Chairman of DDA, whether there was such a visit of the Honorable LG on instructions of the Vice Chairman who is present in court, the learned senior counsel stated that the Honorable LG indeed visited CAPFIMS on that day and not the site where trees were felled. It is pertinent to note that all the 3 emails refer to a visit by the Honorable LG to the site of CAPFIMS Road on 3rd February 24. We direct the Vice Chairman to state before the court on the next date after perusing the record whether any official record is available about the site visit made by the Honorable LG on 3rd February 24 and whether anything is recorded about what transpired during the visit of the Honorable LG. He will state the names of the officers present at the time of the visit. We need a clear statement of fact from the Vice Chairman on these aspects. If what is mentioned in the emails is correct, it will show that the felling of trees was done under the directions issued by the Honorable LG on 3rd February 24. Therefore, we expect the DDA to come clean on this aspect. The executive engineer took a stand before the inquiry committee that the emails were manipulated. However, the inquiry committee has not made any inquiry about whether what is stated in the emails about the visit of the Honorable LG was correct. The crucial aspect of whether the Honorable LG is directed the felling of trees was not discussed during the inquiry. Therefore, we need the assistance of the DDA on this aspect. From the affidavit of Vice Chairman and in particular from para 14 prima facie, it appears to us that the entire blame has been shifted on the subordinate officers mentioned therein by stating that they are the ones who are responsible for directing the contractor to start felling the trees without the permission of the court. In view of the stand taken in the affidavit, issue notice of contempt petition to the executive engineer, assistant engineers, and the superintending engineers. It is stated that Mr. Verma and Mr. Yadav were responsible for the suppression of fact of cutting of trees from the court on 4th March 2024. We direct the advocate on record for the DDA to supply the residential addresses of these officers to the registry. Registry will issue notice. It is an admitted position, as can be seen from the affidavit of the Vice Chairman and what transpired during the course of the hearing, that the contractor under the agreement executed by the DDA was authorized to fell the trees for the purpose of doing the work for which the contract was granted to him. However, it is not stated in the contract that the cutting felling of trees cannot be done without the permission of this court. Learned senior counsel appearing for the Vice Chairman of the DDA assures the court that in every contract, the execution of which requires cutting felling of the trees, the relevant clause will be incorporated of obtaining permission of the court, appropriate authority before cutting felling trees. Needless to add, regarding all subsisting contracts, such a direction shall be issued by the DDA to contractors. After carefully perusing the affidavit and annexures, we find that all the facts leading to the contemptuous act of felling of trees have not come on record. Though it is claimed in the affidavit that the Honorable LG approved the constitution of the three-member committee, the order of Honorable LG on page 334 does not indicate that the Honorable LG approved the constitution of the committee. After the notice is served to the concerned officers, we propose to hold a very detailed inquiry into the gross illegality committed by the DDA, which has destroyed several valuable trees and consequently the environment. The court cannot lightly brush aside such brazen acts in the capital city. If the authorities are not going to perform their statutory and constitutional duty of protecting the environment, the court will have to give a clear and loud signal to all the concerned authorities that damage to the environment in this fashion will not be tolerated. Today, we are refraining from recording any finding on what is stated by the Vice Chairman in his affidavit dated so-and-so, as we will have to hear the concerned officers on whom the entire blame has been shifted. Perhaps during the hearing today, the Vice Chairman must have noticed that the court has serious doubts about the stand taken by DDA about the episode. Therefore, we permit him to file an additional affidavit on all aspects touching the content. The additional affidavit of the Vice Chairman shall be filed before 10th July. The Forest Survey and the three experts have submitted preliminary reports. We direct the registry to forthwith supply soft copies of both the reports to all the learned counsel appearing in the case, including the learned AG. While perusing the affidavit, we came across something shocking. The first sentence of para 38 on page 17 reads thus: the DDA is having the benefit of two judicial officers of Delhi Higher Judicial Service as the legal advisor. Now, this rest I can skip perhaps, unless your lordships want to, because it's not directly on the contempt. The directions are given, my lords. But para 13, if I can read, we need to issue appropriate interim directions based on the two preliminary reports. For that purpose, we direct the registry to list the contempt petition on 26 June. We also direct the registry to place writ petition so-and-so out of which the present contempt petition arises before this court on 26 June. We have indicated to the learned Attorney General and all other counsel that we propose to issue directions in the said writ petition for the conduct of a massive afforestation tree planting drive in the entire NCR. For that purpose, we need to pass consequential orders of impleading parties, etc. On the next day, the learned senior counsel appearing for the DDA shall assist the court on the applicability of the provisions of the Delhi Preservation of Trees Act 94 to the DDA. The next order, my lords, is 26th June. You'll find it a little earlier, perhaps in the PDF. It's at 56, page 56. That's 26th June, my lords. Lords have it?
Yes.
Yes. The learned senior counsel representing the DDA states that today the DDA is unable to make a statement about whether the record relating to the site visit of the Honorable LG made on 3rd February is available with the DDA. Learned senior counsel appearing for DDA seeks time. We do not think that the request for a grant of time to find out such simple information is bona fide. Nevertheless, we grant time of 1 week to the DDA to comply with the directions contained in para 2 of our order dated so-and-so. On instructions, learned senior counsel appearing for DDA states that at the time of the visit of Honorable LG, Shri Ashok Gupta, member engineering of DDA, was present. We therefore direct Shri Ashok Gupta, member engineering DDA, to file a detailed affidavit on exactly what transpired during the visit of the LG. He will also state whether the Honorable LG orally issued any directions. Please note this, we make it clear that Shri Ashok Gupta, member engineering, will file his affidavit not as an officer of the DDA, but as an officer of this court. This is how all the other names come about who all were present. The Vice Chairman of the DDA shall forward a copy of this to Shri Gupta, affidavit within 10 days. Pursuant to the last order, the learned senior counsel appearing for DDA pointed out that there was an exemption granted to the DDA from applicability of certain provisions of DPT Act in the excess of powers under section 29. We have carefully perused the notification dated 14th February, which is annexed to the affidavit dated 15th May 24 of the Vice Chairman of DDA. If I can pause for a minute, this is a notification issued by the Delhi government, which they subsequently withdraw. We may note here that the exemption has been granted only from the applicability of subsection 3 of 9 of the 94 Act. For ready reference, they extract the section 9. In view of the said notification, the provision that the tree officer shall decide the application within 60 days will not apply, which means that the tree officer can take his own time to pass an order. The other consequence of the exemption is that the deeming provision under subsection 4 of 9 will not apply. There is something more shocking about the notification dated 14th February. Clause 5 of the notification reads thus: permission for transplanting, felling of 422 number of trees is being granted to the user agency at their own risk and without prejudice the claims of any person who may be having any rights over the land or the trees. Under the 94 Act, permission for felling trees is required under Section 8, read with Section 9. The permission can be granted only by the tree officer appointed by the government as provided in 52J. The state government has no authority to grant permission for the felling and transplantation of trees. The notification dated 14 February is not an order which exempted the DDA from the requirements of obtaining permission under Section 8 and 9. Apart from this, it is admitted that based on the notification dated 14 February, the DDA is indulged in cutting at least 200 more trees than what was purportedly permitted, 422 trees. The DDA paid the amount payable in terms of said notification on 1st March. Our impression is that many more than 633 trees were illegally felled. When we made a query to the Vice Chairman of the DDA, who was present in the court today, about the place where the timber of the felled trees can be found, the officer of the DDA had no answer. Every single tree has been felled in contravention of the 94 Act. What is required to be done under the 94 Act is immediate seizure as contemplated by Section 15 of the 94 Act. The government of NCT of Delhi is formally not a party, though a learned counsel represents the Forest Department of the Delhi government. The Delhi government will have to answer many questions, including how it could usurp the powers of the tree officer under Section 9 of the 94 Act by purportedly granting permission while exercising power under Section 29 of the 94 Act. In fact, the very notification purportedly granting exemption indicates that the exemption from applicability of the provisions of 8 and 9 was not granted to the DDA. Therefore, the Delhi government must explain how such gross illegality has been committed. Next para, I think the same thing, except the last sentence, I'll read this from the second sentence. Though the Forest Department of Delhi government is fully aware of the gross violation by the DDA of the provisions of the 94 Act, no steps have been taken to set the criminal law in motion against the offenders. In this case, there is an admitted violation of the provision of 94 Act by the DDA and its officers. Even the tree authority will have to give several answers. The learned counsel appearing for the applicant, based on what is stated in the application, claims that the tree authority constituted under Section 3 is hardly functional. We issued notice of this contempt petition to the government of Delhi through the Principal Secretary Environment Forest. The Principal Secretary will file an affidavit explaining how the government purported to grant permission for the felling of trees by exercising the powers of the tree authority under the 94 Act. He will also explain why action was not taken against the DDA, even though the Forest Department of the Delhi government was fully aware of gross violations by the DDA. Thirdly, we direct the Principal Secretary of Environment Forest to ensure that the criminal law is set in motion for taking penal action in accordance with Sections 22, 23, 24 of the 94 Act, as well as other relevant laws. The Principal Secretary and Forest Department shall also state whether the tree authority under Section 3 has been fully constituted and whether the same is functioning. He shall also state the infrastructure made available to the Forest Department. Affidavit shall be filed on or before 11th July 24. We also issue notice to the tree authority under Section 3. The notice will be forwarded to the Principal Secretary of the Environment Forest Department of Delhi government for effecting service to the tree authority. And the rest of the para deals with what the tree authority has to report compliance on. Para 10, we direct the DDA to immediately ascertain the location of the felled trees or parts thereof and communicate the said information to the tree officer within 1 week from today. We expect the DDA to render full cooperation to the tree officer for seizure under Section 15 of the 94 Act. We expect Forest Department of Delhi government and tree authority to keep a constant vigil in the entire area of the National Capital Territory of Delhi about the activities of illegal felling or damaging of trees. Unless these two authorities do so, the very purpose of enacting various forest and tree laws will be completely frustrated. The state government shall immediately create the necessary infrastructure, including the availability of modern technology. While filing the affidavit, we expect the Forest Department and tree authority to state on oath what machinery they have created to keep a constant vigil. Now, next are the preliminary reports which had been submitted. Which part should I read? 14. Para 14, if I can read, brother. At this stage, we may also note that in para 6 of the preliminary report of the committee of the 3 experts, it is stated that the road project site falls inside the eco-sensitive zone around Asola Bhatti Wildlife Sanctuary. A notification of the ESZ has also been annexed to the preliminary report. So this is a new issue which has crept in. It is also stated that strengthening the existing roads and construction of new roads fall under the regulated activities under point 18 of the notification. It is also noted that the road construction has been done without any mitigation measures such as rainwater harvesting, adoption of clean technology for all activities, and restoration of degraded lands, forests, habitat, including water conservation measures. All concerned should note what is observed in para 6 by the committee of experts in their preliminary report. Regarding the Forest Survey of India, the preliminary report states that the field work will be completed by the first week of July 24, and final estimates of the number of trees felled and carbon stock loss will be prepared by the end of July 24. It is further submitted that the final report will be submitted by mid-August 24. We haven't got it yet. From what I understand, we have not got this report yet, unless it's been filed with the court and we don't have a copy. We grant time to the Forest Survey of India in terms of what is stated in paras 21 to 23 of the preliminary report. Forest Survey shall file further preliminary reports. Remember, the rest of the order is dealing with the main writ petition and the directions to that same committee to become a part of a committee which the Forest Secretary will constitute. And then the last order, Manoj, which is 12th July 2024, which should be PDF 31. 12th July. And then the relevant starts at PDF 43. From para 2 minutes, we have perused the 2 affidavits filed by the Vice Chairman of the DDA on 3rd and 11th July. I'm sorry, Your Lordship, have it?
Yes.
We have also perused the affidavit filed by the Principal Secretary Environment Forests. Prima facie, it appears to us that there was a reluctance on the part of all concerned to bring on record what exactly transpired during the visit of the Honorable LG of Delhi to the site on 3rd February 24. Now the truth has come out. The note sheet dated 2nd July of the Chief Secretary of Government of NCT of Delhi has been placed on record by the Vice Chairman of DDA, which discloses what transpired during the visit. Most importantly, Sri Ashok Gupta, the man who had to act as an officer of the court, has filed an affidavit as an officer of this court and has explicitly stated what exactly transpired at the time of the visit of the Honorable LG. We find that the officers attached to the Honorable LG, including his Principal Secretary of Environment and Forest Department, Additional Principal Chief Conservator of Forest, sorry, I missed Chief Secretary, Additional Principal Chief Conservator of Forest, Chief Engineer come Executive Engineer, Principal Commissioner, and Chief Engineer of DDA and his team were present during the visit of the Honorable LG. The presence of the forest officer shows that the visit had something to do with the forest. What transpired in the meeting is reproduced in para 7 of the affidavit. From CAPFIMS Hospital, the Honorable LG stopped on CAPFIMS Road, that is road from CAPFIMS Hospital to Sark University, and walked for a short distance. Honorable LG inquired about the progress of the road construction work and directed to expedite it. Following directions were given by Honorable LG during the inspection. He expressed his concern on the slow progress of road widening work and stressed upon speeding it up. The LG also desired to know as to how the DDA proposes to deal with trees, shrubs coming on the alignment of road portion to be widened. On this, it was informed to LG that permission for felling translocation of trees is awaited from the competent authority. Therefore, the work of felling of trees has not been initiated. On this, the LG informed that for the trees falling under DPTA, the Forest Department has already taken approval from him as per due process on file. He directed the Forest Department to convey the same to DDA at the earliest. The Honorable LG was also apprised about the hindrances coming in the alignment of the portion to be widened. On this, the LG directed the concerned department to take following necessary action. 1. All court cases related to land falling in right of way of the above road should be clubbed together and defended before Honorable Court accordingly. So he is aware of court cases. Some BSAs, electric poles, overhead cables, underground cables, etc. were also causing hindrances in the widening of the road. The concerned officers of BSAs were directed by LG to shift these lines on priority. Some PNG gas pipelines of IGL were also coming in alignment of the portion. This was also to be shifted. Surplus excavated earth was stacked in the CAPFIMS hospital and this earth was required to be removed.
So,
yes,
all the orders, Mr. Shankaran, what you want to then, how do you sum it up now?
So at para 4, last line on that page, the court says we are not examining, or in fact the previous sentence, to be fair, I should read that. It is not clear from the affidavit of Sri Gupta whether any of them pointed out to the Honorable LG about the requirement of obtaining permission from this court for felling of trees from the ridge area, and even otherwise the requirement of obtaining permission from the tree officer under the 94 Act. We are not examining at this stage how the Honorable LG ordered the road widening to proceed in the absence of permission from this court. Now, there's later para 7 deals with the contractor and the logging.
No permission from this court, no permission of the tree authority.
No, nothing. I think this has been admitted by them that they did it without permissions. They came to this court by suppressing the fact. Somebody suppressed it. I don't know who, but they came and sought permission ostensibly.
Yes, now, Mr.
Yes. So I just 3 brief submissions on this.
Yeah, just sum it up. So
yes, I'm summing it. There isn't today, on the record of this court, enough clarity on the part of the DDA all the way up to the LG on 2 things. One, was there any information or discussion on the permission that had to be sought for the purposes of removing those trees? In fact, orders repeatedly show, in the beginning we didn't know about the visit of the LG. Then we find out of the visit of the LG, they name one man. That man is made an officer of this court, he files an affidavit. That man's affidavit says there were these 7 other people. Now those 7 other people have been asked to file affidavits. A few of them have filed affidavits contradicting what this man has said, saying that there was no information given to the LG about the trees or permissions, etc., etc. Now, this needs to be reconciled. In my view, the perfect way of reconciling it is if an affidavit of the LG comes. He is the only person who has to answer that question. There's nobody else.
Chairperson of the DDA.
He's a chairperson. In his capacity as chairperson of the DDA. We are not calling the Lieutenant Governor. Chairperson of the DDA, which is a statutory body. He is a statutory individual who's occupying an office there and he's discharging functions there. He needs to just place an affidavit in this court. There's no problem. Because we now have an AOR, we have a lawyer, etc. There's no problem. So he just needs to file a reply. It's not a formal notice of contempt. It's to provide clarity to this court. I think we all deserve that. That, look, did you have this information that permissions are required? Because 3 weeks later, there's an affidavit being filed by your organization in court asking for that very same permission. So at some stage, you got to know about this, I would presume, that a permission is required. So when was that? And was it never put to you earlier? Now, that's step 1. Whether the person was informed at all. The second is that once you got this information, even if it may be after cutting off the trees, let us presume, what are the steps you took? Because clearly, as chairman, you have found that something under your authority has taken place. Something very, very serious. What remedial steps have you taken? Or on your behalf? And what action has been taken against the officers? For me, I think most critical is the third question, which is when. It cannot be that after a citizen files a contempt petition in this court, that you suddenly start taking action, feeling the heat. All the way up till May.
subject to hearing you. We will ask the chairperson of the DDA to file a personal affidavit explaining what we propose to pass in a short order. Because let the chairperson of DDA disclose to us first, was there any information or discussion on the permission to be sought for removing the trees? Two, when was the LG informed, when was the chairperson of DDA informed about the need for permission? Three, what steps were taken after it was drawn to the notice of the chairperson of DDA for taking remedial measures? What steps were taken for remedial measures? And four, what action has been taken against any official of DDA who had suppressed from the chairperson the fact that there were orders of this court which prevented any tree felling and therefore the need to preserve the pristine environment of the ridge, one. And two, that when the application was filed for permission before this court, trees had already been felled.
I appear for the LG, the LG. But may I just point out certain affidavits which haven't been read, which the court asked for of 29th and 30th July. But in the light of that, my role is actually very limited. It's one day when I came on the 3rd of February to the site and asked for basically for expedition. I had nothing to do really.
You come to the site?
3rd February. I came on the 3rd of February. Now, I made a reference, as your lordship would have seen from the orders passed. On that day, I made a reference to the engineers and other people on site. There were many people who were present. The people.
Now, where did he actually go? Did he go on the 3rd of February to the site of the road?
He went actually to the campus. On his way back, he stopped at the road. That's what's come on the affidavits. He stopped at the site of the road, the road widening, and looked at that as well. But his main...
Yes.
Yes, sir. This is, I'm coming to 29th. Now, my lord, I have had no role to play in this. I only go on the 3rd. The proposal before, the proposal which my learned friend talked about to the Forest Department, the Forest Ministry, started by the department, that is the Environment and Forest Department of the state government, as early as the 23rd. Now, there are a series of permissions already obtained which have had nothing to do with them. The Ridge Management Board, the centrally empowered committee have all cleared this road widening. All it required was the Supreme Court permission and the permission of 2 other authorities. I'll tell your lordship what it was. And I had nothing.
When were the permissions granted actually, and who granted the permissions? Just give us.
Yes, well, if your lordship were turned to an affidavit filed by the Vice Chairman of DD dated 10th July, the entire history in very succinctly set out over there.
Four five.
Sorry.
PDF 1445.
1445.
Five in this document.
PDF page one?
Huh?
Yeah. Additional affidavit on behalf of the...
Additional documents, maybe? Main.
Are you referring to the affidavit of Subhash?
Yes. Subhash Panda, dated 10th July.
He's filed several affidavits for us.
Yes, but I'm talking about the 10th.
No, I'm just...
He's been asked to file several affidavits, but the court asked him to file 13.
Tab 13 perhaps. Once.
He's got. If your lordships kindly turn to page Annexure 5, Annexure V. Sorry, is this V or W? W. Sorry, my lord, Annexure W1 to that affidavit. It sets out, my lord, the history of what happened since 23. I'm reading from paragraph 4, if I may. If the lordships have got it.
Paragraph 4, is it?
Paragraph 4.
All.
CAPFIMS is a prestigious project undertaken by the Ministry of Home Affairs, Government of India since the year 2013. This decision had been taken to meet the long-standing demand of the paramilitary police forces under the aegis of the Ministry of Home, Government of India, for establishment of a super speciality hospital dedicated for the personnel of the central paramilitary forces, including those who are seriously injured in field operations at the border or in the hinterland or by insurgents, on the same pattern as is available for the medical treatment of armed forces personnel. Since this is going to be the first hospital primarily and predominantly for the treatment of personnel of paramilitary central police forces, it has been decided by the Government of India to maintain and operate this hospital under the aegis and supervision of AIIMS, Delhi. For achieving this objective, all requisite permissions for setting up of this hospital at the present location had been obtained, including the permission from the CEC, the Centrally Empowered Committee, and from the Honorable Supreme Court. At an expense of more than 2,200 crores, this hospital project stands completed. Now, my lord, permission was granted for the hospital, but my lord, what really now required to be done was to make easy access available by road widening and getting the road ready. This project had been envisaged to commence in the year 2013. However, the commencement of the construction of the project could only start in the year 2017. Already there has been a long delay in its commissioning for lack of coordination between wings and departments of governments and various other authorities. Accordingly, to ensure completion and commissioning of this project expeditiously, Office of the Honorable Lieutenant Governor had been briefed through a detailed presentation on highlighting the bottlenecks and hurdles coming in the way of timely early completion and commissioning of this hospital. Honorable Lieutenant Governor visited CAPFIMS on 3 occasions thereafter, i.e. on 8th November 2023, 25th November 2023, and 3rd February 2024. Well, the vital date when I'm supposed to have given a direction to the site engineers is on 3rd February 2024, the last one. During these visits, senior officers of key departments of GNCTD, along with officers of the Ministry of Home Affairs, so-and-so project director and so on, officers of DDA, Officer of Traffic Police and project contractor were present. During the course of the visit to CAPFIMS on 3rd February 24, Honorable Lieutenant Governor took stock of the status of the project. Well, this is not, well, I only go there to expedite the matter. This is not really, it's a Ministry of Home project. I am only asked to see that it's being done expeditiously. Honorable Lieutenant Governor, for better coordination amongst various agencies concerned, directed all the officers of concerned agencies' departments present during the visit to expedite the works actions pending on their part so that CAPFIMS Hospital can be operationalized at the earliest. Such works actions included rectification of the shortcomings identified in the CAPFIMS building, procurement of necessary equipment, providing rainwater harvesting facilities inside CAPFIMS campus, including development of a water body, greening activities inside the campus, expedited road widening project as the same would serve not only CAPFIMS Hospital but also the adjoining CBI housing complex as well as the International SARC University under the Ministry of External Affairs, shifting of electricity poles, shifting of IGL gas pipelines, development of water bodies in the low-lying depressions in the vicinity of CAPFIMS campus. Mounds of earth on the fringe of the campus may be used for filling the low-lying depressions in the vicinity. It may be seen that as per the records, a proposal was moved in the Forest Department of the Government of NCT of Delhi for notification under Section 29 of the Delhi Preservation of Trees Act 1994 for felling of 422 trees in a non-ridge area for construction of approach roads spanning approximately 10.525 kilometers from the main Chhattarpur Road to Sark University, Camphins, and other establishments at Maidan Ghari, Sarpur, and Satbari in New Delhi, was placed before the Honorable Lieutenant Governor on 30th January 24. This proposal was, Madam, please see, I am only a signing off authority on this, recommended by the technical officers working in the Forest Department, GNCTD. Thereafter, APPCF, well, that's the additional principle.
Under section 29, who does it have to go for?
Well, it has to go to the Forest Department.
Tree officer.
The tree officer.
Under 29, exactly.
Tree officer under 12, etc. There is an exemption power under 29 which goes to the Delhi government. So first an exemption is to be granted. Thereafter, not formal permission is to be obtained from the tree officer.
That's correct.
Where is section 29? Where do we get section?
It's in the Prevention of Trees Act.
Do you have a copy of the section 29 of the Prevention of the Delhi Preservation of Trees Act 1994?
Yes. Delhi Preservation of Trees Act. No, what? 29.3 really is an exception to 9. Under 29.3, if the area which you are trying to clear and you want felling of trees exceeds 1 hectare, you require this permission under 29. Having got that permission, then the tree officer can then give permission to cut those trees.
Let's see that.
Sorry, we have only 2 copies.
Have you got one more copy? Yeah. Please, your Lordship will kindly turn to 9 first. Before reading 29, if your Lordship kindly have a look at 9. And about 9.3 is really relevant, but your Lordship may just read 9.1 and 2. And 9.3 is the relevant subsection. The proviso is important. That's the proviso brings into operation 29.
Now, where is the 29? Where is the notification under 29?
Now, that came on the 14th of February, 24.
Where is that?
It's a part of the same affidavit.
What page is it?
Annexure X. To that very affidavit, annexure X, which is internal page 144, 145, 146, where Malord clause 5 has been reproduced in the order by Justice Rowe. Annexure X. Okay.
for felling, for the original permission contemplated was for 422 trees.
Yes.
And in the non-ridge area.
In the because it's a part of the forest, the non-ridge area, not part of the forest ridge.
Now, what was felled was 1100 trees. Now,
but that my learned friend will be able to tell you a lot.
The Delhi government has filed an affidavit explaining the three methods that are followed, because this area included area which is forest as well as non-forest. Different permissions are required for each. The Delhi government in its affidavit has said category 1 is part of ridge which is notified as forest. This is at PDF 1324. This is what they have said. So part of ridge notified as forest has 4 stages. The first is the recommendation of the Ridge Management Board. Second is recommendation of CEC. Third is approval of Supreme Court. And fourth is final permission under the Forest Act. Now this is all for ridge areas which are notified as forest.
And trees have been felled both from the ridge area and the non.
In both. That's why. So now the ridge which is outside the notified forest, which is morphological ridge as they refer to it, which is not a notified forest, for that, Ridge Management Board, CEC and Supreme Court, after which final permission is under the Delhi Tree Preservation Act. So for that final permission, your Lordship saw Justice Oak's earlier order, where the same argument was taken. He said the 29 exemption doesn't amount to a permission under 8 and 9. You separately need to apply for permission under 8 and 9, which is the position they have admitted, that they didn't need the permission under 8 and 9.
1100 figure is only the petitioner's statement before the Honorable High Court, my lord, they travelled, which my lord, the Honorable Justice O considered and therefore said that the permission for 422 trees are 200 plus. And the actual number, my lord, has also come in the report of the committee appointed by this Honorable Court. We'll show it to your Lordship, my lord, later.
So, Lord, the position is that, sorry.
Yes.
The position is, my lord, therefore, as far as both the non-ridge and ridge trees are concerned, the CEC had signed off and the Ridge Management Board had both signed off in 2023 itself. Now, what was left was 3 statutory permissions, one under the Section 9, which was sought and obtained on the 14th of February, and on 15th February, the tree officer also gave permission. But now that permission is not really permission, I must fairly concede, but that was misconstrued. So, the last permission left after those two was the permission of the Supreme Court, which was not obtained. So, Ridge Management Board, CEC, and the 29 permission, because the area was larger than 1 hectare, were all obtained. The 3 officers' permission post that sanction under Section 29, that was not obtained. A letter was issued on the 15th of February, but it wasn't a clear letter that you could actually fell the trees, but it talks of a permission. And the last one, my lord, was the Supreme Court, which, my lord, admittedly has not been obtained. Now, my lord, why was the Honorable Lieutenant Governor sought to be involved in this, my lord? It is true he went on the 3rd of February. He only went to see the status. Well, nobody will listen to his directions, as I'll point out from the affidavits. He's not the signing, he's not the final authority in this matter, and he was told so. And I'll point that out. What he did was, he just said, please expedite this process on that date. Now, kindly see, my lord, who recommends this?
As far as the ridge area is concerned,
yes,
permission was required under the Forest Conservation Act?
Yes, sir.
When was that taken?
But the permission had to be obtained from your lordships. The Ridge Management Board had given a positive recommendation in 23. Then, my lord, the CEC, my lord, of your lordship.
First March 24, to answer your question.
Is on first,
Sorry?
First March 24,
Was by whom?
by the central government, under the Forest Conservation Act,
For 1st March 24, that was granted by the central government.
after the cutting.
So the only thing that remained was really our permission.
So, lordship,
First March was after the tree cutting.
Yes, sir. Now I'll tell your lordship about the tree cutting as well.
The tree cutting had started sometime in February itself.
As per their own statement, 16th February onwards, 7-8 days it went on. And nobody saw it.
Now, my lord, I'm really answering for the LG. Was it caused because of me? Was this the entire procedure? No, it's not as if anybody is obliged to listen to me, and they didn't listen to me. I'll tell your lordships why. I came on the 3rd of February and I left.
You mean to say all this was done by the subordinate official?
No, I'm not saying that. I'm not saying that at all. Now, my lord, kindly see what happened.
What happened to the timber? Where is the timber gone? 1100 keys are felled.
My lord, frankly speaking, I don't monitor the timber, but the DDA will give your lordship, and it has given in the affidavit. From what I've seen, that's the DDA will tell your lordship what happened to how many trees were felled and where is the timber. Yes.
But when was the timber removed?
of that.
May 1996. While dealing with IS 18 and 22, in writ petition civil number 4677 of 1985, MC Mehta versus Union of India, this court had specifically referred to the master plan for Delhi, perspective 2001, which stipulated that, into invert commas, no further infringements of the ridge is to be permitted, semicolon, it should be maintained in its pristine glory. Good stuff. I 40494 of 2024 was moved by the Delhi Development Authority, bracket DDA, in Writ Petition Civil 4677 of 1985, seeking to fell stroke translocate 1051 trees. Good stuff. When the IA came up before a two-judge bench consisting of Honorable Mr. Justice Abhay Oka and Honorable Mr. Justice Ujjal Bhuyan, the court observed that into invert commas, the application is very vague, into invert commas complete, and that is the duty of DDA to first make an attempt to protect the environment by seeking only the felling of those trees, which was absolutely mandatory. Moreover, DDA was directed to apply its mind as to whether there were other alternatives which could be examined to save the trees, bearing in mind, having due regard to the fact that the felling of trees was proposed from the central ridge, from the southern ridge. Let's stop. The court noted that DDA proposed to construct a road through a forest for which no permission had been obtained under the Forest Act. Accordingly, the following directions were issued. Para 12, Kalije, Volume 1, May, page 46. The application, which was filed by DDA, was dismissed, though in terms of the liberty which was granted to it. A report was submitted on 22 April 2024 by the Central Empowered Committee on 8 February 2023. Another two-judge bench of this court, consisting of Honorable Mr. Justice B.R. Gavai and Honorable Mr. Justice Vikram Nath, passed an order in Writ Petition 202 of 1995, into brackets, in re T.N. Godavarman Tirumalpur, specifically mandating that until that into inverted commas, until further orders, the DDA shall not allot any land in the areas which are under consideration for being notified as a protected area. These directions were specifically issued in relation to a proposal for the diversion of 6,200 square meters of morphological rich area for the construction of certain premises for the DRI headquarters. Let's stop. A report was submitted on 22 April 2024 by the Central Empowered Committee, brackets CEC, brackets report number 4 of 2024, in repetition 202 of 1995, indicating that despite the dismissal of the IA, despite the dismissal of DDA's IA seeking permission for felling of trees on 4 March 2024, a site visit on 10 and 18 April 2024 by the CEC in the presence of the officials of the Forest Department of Delhi and the DDA indicated that work had already been started by the DDA in the said area and land breaking had been carried out for the construction of a new road. At that stage, the CEC noted that according to a report filed by the Deputy Range Officer, 222 trees had been felled in the non-forest area, where permission under the Delhi Protection of Trees Act 1994 was required for felling, and 523 trees were found to have been felled in the ridge area, where the approval of the central government under the Forest Conservation Act 1980 and the leave of this court was required before any felling of trees. The CEC while noting a violation of the orders passed on 8 February 2023 in Godavarman and on 4 March 2024 in MC Mehta, propose the initiation of action against the concerned officers of DDA for non-forestry use of 3.6 hectares of forest land for the construction of an approach road from the main Chhatterjee road to Sark University, CAPFIMS and other establishments at Maidangadi and Sadbadi under the South Forest Division in South District of NCT, Delhi, without the approval of the central government. The CEC also proposed action under the penal provisions of the Delhi Preservation of Trees Act, Preservation of Trees Act 1994 against the concerned officials of DDA for felling trees without the approval of the tree officer. On 24 March 2024, a notice of contempt was issued by contempt.
I'm sorry, 24th April, Manoj.
Yeah, 24th April. On 24th April 2024, a notice of contempt was issued by this court into brackets. The bench consisted of Gavai and Sandeep Mehta JJ, prima facie noting that the action of the DDA in felling the trees and constructing the road was in contempt of the orders passed on 8 February 2023 and the order dated 4 March 2024. On 9 May 2024, another two-judge bench, into brackets, consisting of A.S. Oka and Ujjal Bhuyan JJ, while issuing a notice of contempt in diary number 21171 of 2024, restrained further tree felling and ordered the maintenance of status quo. Let's stop. On 14 May 2024, the Vice Chairperson of DDA was directed to file a personal affidavit on the proposed restoration measures intended to be taken and to indicate at least the approximate figure, a number of trees felled, and the names of the officers of DDA who authorized the felling of the trees. On 16 May 2024, the two-judge bench recorded, after perusing the affidavit filed by the Vice Chairperson of the DDA, that the conduct of DDA in felling over 1100 trees without the permission of the court was a matter which shocked the conscience of the court. The court noted that the court has taken note of the fact that the application for permission to fell trees, the application to fell, into inverted commas, a large number of trees, which was supported by the recommendation of the CEC, had been filed on 15 February 2024 by DDA, and the actual felling of trees commenced on 16 February 2024. The felling of trees continued until 26 February 2024. The fact that the felling of trees had commenced even before the filing of the application was suppressed from this court. The DDA was fully aware of the fact that without the permission of the court, no tree could be felled. The court observed that in pursuance of its directions dated 4 March 2024, for the constitution of a committee of eminent experts a proposal was approved on 12 April 2024 by the chairperson of DDA. Court noted that the chairperson of DDA, the Lieutenant Governor of Delhi, appeared to have been misled while taking his approval on the proposal based on the observations of this court. The court specifically, the court, while issuing notice of criminal contempt to the vice chairperson of DDA, called for a time-bound scheme for carrying out the work of restoration, noting that DDA had indicated on affidavit of the vice chairperson that 1100 trees had been felled. Good stop.
Lord, 1100 was a statement of the petitioner in Delhi High Court.
No. This is, they have at page 98 of volume 1,
yes,
where Justice Oak records. Now we come to the number of trees which have been felled in paragraph 7.5 of the affidavit of the vice chairperson of DDA. It is stated thus: Chief engineer along with his staff visited the site and found that out of 422 trees identified for felling, 174 trees had been cut on DDA private land.
Correct.
Similarly, out of 629 trees on forest land, 458 trees had been cut, 248 trees on DDA private land, and 161 trees on forest land are still standing. However, our attention was invited to an order of the Delhi High Court, in which it is recorded that the DDA itself stated that about 1100 trees have been felled for the same purpose.
Corrected, only, my lord. if your lordship told, one second, if your
No,
lordship
we are only quoting from Justice Oak's order. We are not finding that 1100 trees were correct.
My lord, I'm obliged. The subsequent order, my lord, Justice Oak has recorded that the permission was for 422. You have felled additionally 200, which figures is 650.
That will come back.
I'm only on.
Yes. Thereafter, a series of orders came to be passed on 24 June 2024, 26 June 2024, and 12 July 2024. Good stop. From the material on the record, it is transpired that on 3 February 2024, the Vice Chairperson of DDA had visited the site. Sorry, the Chairperson of DDA had visited the site and had inter alia directed expediting the project of road widening. Good stop. At this stage, the material on the record is ambiguous on certain critical aspects on which a further elaboration will be required. These aspects are set out below, bracket 1, whether during the course of the site visit on 3 February 2024, there was any discussion with or intimation furnished to the Chairperson of DDA on the permission required to be obtained from this court for the felling or removal of trees.
Sorry to interrupt your lordship. There are two affidavits filed of 29th and 30th, which deals with that aspect. I was going to read. One is of the all persons present on the site. Who were present on that site visit.
We'll just go to that.
I was going to read that before the.
Two. Secondly, in the event of the answer to one above being in the positive, what steps, if any, were taken in pursuance of what steps, if any, were taken to ensure that the permission of this court would be obtained before the actual work of felling took place, semicolon. 3, in the event that the answer to one above was in the negative, when was the Chairperson of DDA first made aware of the fact that A, permission for the felling of trees from this court was required, semicolon, and bracket B, the actual act of felling of trees had commenced on or about 16 February 2024, even before an application was moved before this court and which was eventually dismissed by the order dated 4 March 2024. 3. What, if any, steps have been taken for the remediation and restoration of the ecological damage which has been caused for the felling of trees despite the admitted absence of any permission from this court as required by the orders referred to earlier. Semicolon 4. What steps have been taken to identify the officers responsible for bracket A, the willful act of suppression from this court in the application filed for permission of the fact that the felling of trees had already taken place even before the application was filed, without intimation. When the eventual orders were passed, when orders were passed on 4 March 2024, rejecting the application for permission. B, whether any disciplinary proceedings have been instituted against the officials responsible and C, whether in the view of the chairperson of DDA, criminal action should be taken against all officials responsible for the breach of the binding directions of this court. Full stop. In the event that the chairperson of DDA is of the view that such criminal action, that disciplinary action and the initiation of criminal prosecution should be taken up, we would expect that such action should be taken in the interregnum without awaiting for the directions of this court. Full stop. The affidavit which has been directed to be filed shall be personally filed by the chairperson of DDA, making a full disclosure both on the basis of the material on record and of facts which are personal to the knowledge of the chairperson, bearing in mind what transpired at the meeting which was held, and bearing in mind what transpired at the site visit on 3 February 2024.
But only one.
Who are they referring to?
A compliance affidavit shall be filed before this court on the next date of listing. By the next date of listing, full stop. The affidavit, the chairperson of DDA before this court by the next date of listing. Full stop. The affidavit shall also specifically explain the manner in which the timber of the trees which were felled, has been dealt with and shall and the steps taken to attribute accountability to any officials found to be in breach of the provisions of the sorry, क्या लिखा मैंने? Has been inventorized, shall indicate whether the timber of the felled trees was inventorized and the manner in which it has been dealt with. Full stop. The chairperson of DDA shall take steps before the next date of listing to affix accountability in respect of any act of omission or commission on the part of officials or third parties involved, and file. Full stop. A compliance affidavit on all the above aspects shall be filed before this court by the next date of listing. List on, we'll keep it next Tuesday.
But I didn't want to interrupt. No, some of the aspects have already come. Some of the aspects which
we don't want this to be told to us by the vice chairperson or any other officer. We want the chairperson to tell us.
I'll only be repeating what they say, but I'll do it better because actually on the ground they've been collecting the timber and all.
Only as a matter of fact, I just wanted to point out to this honorable court that will get added, my lord, whatever in the banner you
But Mr. Mender Singh, we have asked for an affidavit on the basis of the records and on the basis of personal knowledge. So we made a very careful and guarded statement.
Give information there. It's a
just one second. Yeah. Only as a matter of clarification, since my lord, the affidavits were not gone through, that some of the aspects which your lordship dictated, we have no problem. Nobody can have a problem if somebody puts it on affidavit. It's already a part of the record, and my friend said it would get repeated, but that's a part of the record.
But this time, if it is repeated by the chairperson takes personal responsibility for what is informed to us. That's why we have category. We want the highest authority that
your lordship must get satisfied, my lord. Of course,
we must be satisfied on what is being done. And before we take action, we want action to be taken by DDA, so that by this date, within 1 week, we want action both in terms of disciplinary proceedings, 2, initiation of criminal prosecution, and 3, accountability in respect of everyone involved, including in the lifting of the timber.
Report has come, my lord. So it's placed on record also.
Lords, 26th June, your lordship's order had said that FSI report has to come. I understand the report has still not come. So if your lordship can indicate, it can come. The final report of that committee.
The final report of the expert committee, which was constituted in pursuance of the order dated 26th June 2024, shall be submitted to this court by the next date of list.
Just one more category, because some of this can't be in my personal knowledge and may not be on the record.
No,
on information provided to him also.
Well, you can say that yes, this is on the
so because that might be
right.
Grateful.
Most good.
Unless there's a second contempt.
Yes, Ms. Bhatti.
Unless there's a second contempt in this, that also has gone along with this.
I've requested for detagging. That's that 9.1, which is on the
southern bridge. Detagged in the morning.
Then my lords may detag because in this case, it is our case that not a single tree has been felled. This is Buddha Jayanti Park. Let it also be listed next week, my lords.
All right, but we'll detag it.
No difficulty. No difficulty.
And we'll dispose it off next week if there's no. We'll look at it briefly and dispose it.
Because we are for the respondent.
Mr. Maninder Singh, we want the chairperson to now wield his authority and ensure that action is taken on the ground.
Of course, my lord, that your lord, as I said, my lord, the satisfaction of the court must be reached.
Yeah.
My lords are keeping this contempt on Wednesday, the second contempt, my lords?
Tuesday.
I'm grateful.
Because I appear for the respondent here. This arises out of my lords.
For the petitioner, my lords.
Just one second. Give us only 1 minute. We'll just go to the brief.
Yes. My lords, I am for the petitioner. We have instructions to withdraw under unfortunate circumstances, my lords. The arbitrator who has been appointed by the High Court had passed away, Justice Devendra.
What was the application for actually?
For 29A for extension, for extension of time for passing the award.
This is a property worth about 800 crores. What I am suggesting.
On the question of maintainability,
The issue tell us, because somehow, because since it was 32, I thought this would be an after notice matter. It is an after notice.
It's an after notice, and some of the respondents have not even been.
You had moved an application for extension of time.
The extension of time, the arbitrated are almost
before the High Court.
High Court.
Who is the arbitrator?
Justice Devendra Gupta. Unfortunately, it passed away.
Now,
on the last occasion, they did not.
He passed away after the impugned order of the High Court.
After the impugned order, and after we filed our SLP.
Oh, so what is the date of the impugned order?
The date of the impugned order, is 10/5/24.
10th of May 24. And when did the learned arbitrator pass away?
17th June.
17th June, my lords.
17th of June.
June.
And it was your application for extension of time to complete the proceeding.
Which unfortunately they objected on the last occasion when it came up for.
Why did you object to an extension of time? It's an arbitration.
I don't want to go into that. There was a reason which we had articulated. I don't want to go there. I'm only praying this, my lord.
Why don't we do this? Why don't we do this?
Yes.
To obviate any further, rigmarole on procedure. Yeah.
There's in fact 11 coming up before the High Court day after tomorrow.
You are before the Supreme Court.
I know.
We will extend time here.
That's
no, that needs,
and will not appoint a new arbitrator also.
There are two things, the matter is coming up before the High
Court. You are now before the Supreme Court, I say.
By another party, there are
for what? How many respondents do you have here?
4, because
just 1 second.
It refers to a society.
1 second.
Registration Act.
How many respondents?
37, my lords.
There are 3 main groups.
And half of them have not been served. There are therefore we need the consent also. And there's a substantial petition which is coming up before the High Court.
Doesn't mind. I'm a little surprised. They are the claimants. Why are they objecting to appointment of an arbitrator?
Same surprise I had last time when they objected, my lord.
Unusual.
Our award would have been passed by now.
They are the ones who are.
They were dealing the arbitral proceedings.
Yes, my lord.
According to us,
1 year passed. They did not participate at the end.
No.
For Justice Gupta.
And last time, my lords, when the court asked them whether if you give a consent, we'll give extension of time, they objected.
1 second. Why don't you both be reasonable?
Right. That's right.
Come a little closer to each other. Just give us the name of an arbitrator by consent. Both of you agree to an arbitrator. Can you not agree to a name of a retired judge by consent?
Well, the issue is there are 20 other parties who are all parties who need to. All of them are before the High Court. They gave their object and they gave their consent.
They are all represented by counsel. There is 2 sets of people. The arbitration was done, my lords, in a writ proceeding. My lord, we leave it to your lordships. Your lordships.
Now, how many parties are unserved?
No, my lord. The groups are unserved.
There are 18 parties who have been unserved. There is a party who is not party to the.
There are about 37 respondents.
37.
You are appearing for 2 groups in the
society. Only one person matters, the petitioner. Probably one of the groups, my lord.
Which group are you appearing?
The one belonging to the petitioner, my lords. Today, my lords, no
you are
the controlling.
You are the petitioner.
I am the petitioner.
You are one group in the cooperative society.
Yes.
All right, and Mr. Tripathi?
Well, I am for the respondent group, Apparao group, and there is a third group of counter claimants who have also not moved in. They have also been served. Every one of them in the group is not.
Why don't we do this?
He is representing the R17, I was told. That's the problem.
Why don't we do this?
Yes.
You serve the lawyers who are appearing in the High Court.
Through the High Court, man.
Through the High Court. All right. Ideally, if all 3 of you can, show some reasonableness, and all 3 of you can identify one arbitrator, you can do it. Right. Otherwise, if you can't agree, we'll do it. There's no difficulty. We'll extend time. Yeah. We'll issue directions to all parties to cooperate in the arbitral proceedings. But first and foremost, we must always give parties that if you can put your heads together and give us then nothing like
then, my lord, sometimes to serve all the other parties.
We will of course do that.
It's the only time.
But we would expect, you're
definitely, my lords.
Still appearing in the matter. Surely, you people must sit down over a cup of tea and say, all right, 5 arbitrators, pick one out there.
Wonderful hospital, my lords.
Lords will not insist on the tea part. But yes,
why do you have to bring every fight to the court?
Actually, to come to an end if they are not given that, if they are not objected last occasion, my lord.
Well,
anyway.
Now, if you keep on pursuing your litigation, you're the claimant. If you keep on pursuing this litigation, you will have another SLP in the next stage over here. So what you do is this.
Yes, sir.
We will say that the issuance, I think that will be best. Let them, right?
For day after tomorrow, which is coming before the Honorable
You
Chief.
just tell them that we are that you are trying to resolve it over here, in which case we can resolve it over here.
And we'll also inform those who will be there in court.
And whoever is there, all the lawyers who are appearing for the contesting parties before the concerned court.
That's right.
Give them copies, they can appear online. You can sort it out, and please in the meantime sort it out between yourselves. You agree to an arbitrator by consent. We will extend time, we'll grant time, whatever all three groups think is appropriate. What stage was reached in the arbitration proceeding? Evidence was concluded or not?
Almost final stages.
So it's only the final argument.
Just
so we may extend time by say 6 months or 4 months, whatever you
you're looking for. Well, and one more thing, the learned AOR who's now appearing in this matter is appearing for all the claimants.
No,
arbitration. That's what I said.
There's one petition which is coming for the High Court.
We'll see to it that the laws.
Since the office report indicates that some of the parties who are appearing before some of the respondents remain to be. The office report indicates that some of the respondents appear to be unserved. Full stop. The High Court, by its impugned order, rejected the application for extension of time for completing the arbitration proceedings on the ground
jurisdiction.
On the ground that it was not the appropriate court, in the meaning of Section 21E of the Arbitration and Conciliation Act 1996. Full stop. At this stage, we have proposed to the Learned Counsel that it would be appropriate if, full stop. At this stage, the court is apprised of the fact that broadly speaking, the parties to these proceedings are comprised in three groups. In the cooperative society,
it's a society's registration act.
In a society under the
registered under the society.
In a society registered under the Societies Registration Act 1860. Full stop. Correct.
AP societies registered.
Under the
Andhra Pradesh
Societies Registration Act 2001. Full stop. In order to facilitate the early full stop, it appears that before the sole arbitrator into brackets, Honorable Mr. Justice Devendra Gupta bracket passed away, the arbitration had proceeded to a substantial extent. Full stop. In this way of the matter, bearing in mind the need to complete the arbitral proceedings expeditiously, we have proposed to the parties that the remaining parties who have to yet be served may be served to the counsel appearing before them, before the court below. Full stop. This exercise shall be carried out on or before the next date of listing, so that they may appear before this court, either in person, either through an advocate or through the video conferencing platform. Full stop. Parties may, in the meantime, also deliberate amongst each other through their counsel on whether they are agreeable to the appointment of a sole arbitrator by consent of a person they may nominate, failing which, the court may do so for failure of agreement. In the event of a failure of agreement. So please now put your heads together, have a 15-minute meeting and sort it out and tell us next time. We'll extend time, appoint an arbitrator whom you people want if you can agree, otherwise we'll do that. We'll list it next Tuesday. Next Wednesday.
Just 1 week.
We'll keep it take it. That'll be the holidays. We'll keep it. Not in the holidays, please. We'll keep it next Wednesday. Next Wednesday, we'll sort it.
It's Friday, because there's a lot of parties who have to be served.
Friday, they're all in the High Court. No? Yes, now, who else?
Lord's marital rape is listed tomorrow. We're all here. We'll be tomorrow here first.
We'll be first on board. We'll start tomorrow.
So grateful, my lords.
I was only.
We'll see. Who says, but we still have a lot of time.
Yes. My friend says, can it be done on Friday, my lord, instead of Wednesday? Friday instead of Wednesday.
You want it
Friday instead of Wednesday.
All right, take it Friday week. No problem. Mr. Tripathi, where's Mr. Tripathi gone?
Tomorrow I am in a overnight part before court 5, my lord. Your lordship can have it next week, my lord. I don't see, my lord, it's that urgent. My learned friend is mentioning
Let them start.
1, 2, 4.
It's the next matter on board. Let them start tomorrow.
So may I mention item 33?
Yeah, item 33.
The medical admission matter. If your lordship can take it tomorrow morning first.
33. That is the Telangana matter or what?
Mentioned yesterday.
My lord.
Sorry?
It was mentioned yesterday for urgent listing today. My lord can take it tomorrow first.
All right, just mention in the morning. We can. Who's on the other side?
It's a fresh matter. It's a fresh matter.
Nobody's on the other side. All right, we'll keep it higher in the fresh.
There is one matter.
So may I have the liberty to?
Lord, your lordships have heard it. I'm not addressing. Lord, kindly have it tomorrow. Lord. That is also item 31.
So it's to mention in the morning. We'll take it. It'll be on board tomorrow. These matters won't get off the board tomorrow.
Please.